Good afternoon, everyone. Welcome to our event. My name is Michele LeVoy. I'm the director of PICUM, the Platform for International Cooperation on Undocumented Migrants. We'll be doing this in English, French, and Spanish. So if you need interpretation, we have headsets here. Please feel free to get them if you need it. So we want to very much welcome you to our legal seminar. We're doing this together with Equinox Initiative for Racial Justice in the VUB. And this legal seminar is the fourth in a series of legal seminars that PICUM has been organizing since 2017, looking at EU law and its impact and relevance for undocumented migrants. So very much happy to do this with Equinox and to do it with the VUB. I wanted to especially thank two people from the VUB who aren't in the room with us, but I want to thank them anyway. Tuba Birkan and Wali Ahmad Yar for stepping in so quickly, because last week, literally 7 days, we were supposed to be in a different venue. And the other venue didn't work out. I'll just say it very shortly, it didn't work out. So I also wanted to start by thanking some from the PICUM team, who I would maybe call the PICUM magician team, who magically got us here to this wonderful venue in this space. So very much thanks to Louise Bonneau, who's been organizing this from the beginning, Alyna Smith, Irene Subiri Martin, and Chloe Bouvier, as well as all the others from the PICUM team who've been helping to really mobilize very, very quickly to move the venue. So in terms of what we will be looking at today, what's one of our starting points? Here I wanted to highlight the principle of non-discrimination, which is really at the heart of what we're looking at, which is embedded in EU law, notably the EU Charter of Fundamental Rights and the Racial Equality Directive from 2000. Yet, even though we have this legal framework, the reality on the ground, which all of you know very well, is that racial discrimination, seeing migrants as the so-called other, is linked to migration policies and practices. How do we see this playing out? We will hear from all of you and we will analyze many different examples. I wanted to highlight a couple from our newsletter, which we just released a couple days ago, which go a little bit broader than what we're looking at today, but also which kind of highlight how some policies are seeing migrants as the other. So for example, policies which blame migrants because they don't adhere to EU values. So for example, in Sweden, the government is considering legislation that would allow the withdrawal of residence permits of people who, quote, do not adhere to basic norms and do not live in an honest and well-behaved way. So the Minister of Migration has said this. What could some of these infractions be? They could mean that undocumented migrants who suffer from substance abuse or who are having debts could be not adhering to the norms, and so their residence permit could be taken away. Policies that question children if they're really children. In Spain, we see the police incorrectly classifying many child migrants as adults in the Canary Islands. Amnesty International has done an investigation which saw that 12 out of 29 interviewed migrants under 18 were wrongly labeled as adults. Or some other policies which are restricting access to services. And this one is a particular concern. France has had legislation for healthcare for nearly 30 years, which is quite broad. It's broader coverage than emergency care. But last month, the French Senate voted to eliminate the aide médicale d'État, which is the broad healthcare, and replace it with emergency medical healthcare. And this emergency medical healthcare would only cover life-threatening conditions and acute pain. This was voted despite recent research showing that the current system is cost-effective and benefits public health overall. So these are obviously broader, but our focus today will really be on policing and immigration enforcement, which we increasingly see as being interconnected. And people who are racialized bear the brunt of this. in the form of heightened criminalization of movement, increased stops and searches, and a heightened experience of violence. So this is why this year our focus of this seminar is looking at the intersection of racial profiling, policing, and immigration control. And as we speak, the EU itself is actually negotiating the Pact on Migration and Asylum. We find a lot of challenges between the aspirations of the EU Action Plan against racism, which hopefully we'll hear a little bit about in the next panel, and the Pact on Migration. Both of these policy tools and instruments were launched within days each other in September 2020. We find that a number of the elements of the pact go in the opposite direction from the principles of racial justice. So for example, the Commission proposal on the screening regulation has introduced new grounds for apprehension and potential detention in ID procedures for people that might look like migrants, both within the border and EU territory, or the asylum procedures regulation, which would channel people into procedures that provide them with more or less guarantees on grounds, including nationality. We also see issues with some of the provisions in the Eurodac regulation and the AI Act, all of which we'll hear more in detail on the coming panels. But all of this is a very bleak picture. And here, before decisions, which are actually quite hopeful and promising. One was just from last month. The Human Rights has ruled against North Macedonia in a landmark judgment, which condemns racial profiling of Roma at the border. The judgment is Mammadova and others versus North Macedonia. And another one was from 2019, which many of you might be familiar with. Acting on behalf of 25 undocumented Malian construction workers, the French Défenseur des Droits brought a case of labor exploitation before the French Labor Court. The case was won by a finding of the Court of Labor Abuse, which constituted systemic discrimination on the grounds of race and ethnicity. And finally, to end and to segue into our next speaker, from the UN level, the United Nations Committee on the Elimination of Racial Discrimination, so CERD, and the Committee on the Protection of the Rights of Migrant Workers and Their Families, the Committee on Migrant Workers, CMW, have agreed to jointly prepare a general comment on xenophobia and its impact on human rights. So this joint general comment, which is foreseen by the end of 2024, will be an authoritative guide on the obligation of states to design and implement a comprehensive public policy to combat and eradicate xenophobia and its effect on the rights of migrants, their families, and on societies. It's actually going to be a very broad range of issues that the Joint General Comment will look at. It'll look at access to justice, education, employment, health, protection policies, local policies, hate crimes, communication, technology, social networks, and also look at intersectional policies against racism, racial discrimination, gender and sexual diversity, youth, childhood, disability, amongst others. What's also of reference for us is that although now only 60 countries around the world have ratified the Convention on Migrant Workers, no EU member states, there's 182 states that have ratified the CERD, including all EU member states. So that's also what's useful for us, is this will be a joint general comment. So we very much welcome those of you who are online, those of you who are in the room, community organizers, practitioners, people who are working with racial justice, migrant justice, prison abolition, all the related movements. We're very grateful to have all of you here. We're very grateful to the chairs and to the speakers, so thank you very much in advance. And then just practically, those of you online, please feel free to ask any questions in the chat. There will be workshops tomorrow, and we have some sign-up sheets in the hall here, so please feel free to sign up. And now I'd like to hand it over to our keynote speaker, Tendayi Achiume, who's the former UN Special Representative on Contemporary Forms of Racism. She graciously has agreed to do a video for us. She's not based here on this continent or in this time zone. So we will now see a video and then we'll go into the first panel. Thank you.
Thank you very much to PICUM and Equinox for convening this event and for the invitation to deliver this keynote. I very much wish I could join in person or be live with you virtually, but unfortunately I'm unable to do so, so I recorded something in advance. Before getting into the substance of the theme of this legal seminar, I want to express my profound appreciation for what both PICUM and Equinox represent. PICUM's explicit focus on undocumented migrants is focused not only on human rights, but also justice for people who are regularly portrayed as less than human because of their legal status is just so vitally important. And Equinox's focus on racial justice in a world and in a region where racism is systemic, but where those fighting for equality and justice are often vilified, is also vitally important. I draw a great deal of inspiration from both of these formations, and I just wanted to express my sincere thanks for the work that you do. The focus of this legal seminar is racial profiling, policing, and immigration control. It places an emphasis on the concrete reality of how heavily policing and border enforcement rely on race, ethnicity, religion, descent, national origin, and related categories to determine who will be subject to the punitive authority of the state. My very first report in my former role as Special Rapporteur on contemporary forms of racism focused on racial discrimination in the context of citizenship, nationality, immigration laws, policies, and practices. In that report, I highlighted the prevalence of racial profiling in immigration enforcement as a global issue. And I also highlighted the international legal frameworks in place that prohibit racial profiling. In addition to that report, I published a report that highlighted in particular the growing prevalence of seemingly neutral emerging digital technologies in the border enforcement context that are ultimately resulting in enhanced racial profiling of migrants. Although my mandate was on racism broadly, I focused a lot of my attention on immigration law and policy because migration frameworks all over the world are mechanisms through which racial subordination is achieved, including through the suspension of limits on state power that are otherwise unthinkable. In today's world, race is itself a border. And what do I mean by this? What do I mean when I say that race is itself a border? I mean that, among other things, the social construction of race operates as border infrastructure, much in the same way that border walls or immigration security checkpoints or other technologies do. In other words, race forms part of the institutional and physical apparatus determining access to territory and also access to human rights. In the European Union, the perceived race, ethnicity, or religion of human beings, the color of their skin, the texture of their hair, their accents, all function as infrastructure that can designate them as presumptively lawful or unlawful, as deserving or undeserving of punishment or expulsion. To give but one example, I've written about studies that have found that in the context of highway stops in the Netherlands, among the leading tools deployed by immigration officials to identify potential undocumented immigrants is whether, in the officials' eyes, the individuals driving looked Dutch. And officials in one study equated looking Dutch with whiteness on the basis that although the Netherlands is a racially and ethnically diverse country, it's a predominantly white country. This conflation of Dutchness with whiteness is noteworthy given that the Kingdom of the Netherlands today includes 3 Caribbean national territories, Aruba, Curacao, and St. Martin, that are predominantly non-white. The territories and nations of the EU include many of the non-white peoples they formerly colonized, whether Europeans acknowledge this or not. Officers in the Dutch study were cognizant of possible allegations of discrimination and racial or ethnic profiling, but they perceived profiling as a necessary evil because, as they told the author of the study, how else can you recognize an irregular immigrant? And this is a direct quick quotation from the officers. How else would you recognize an irregular immigrant if not for their race or their ethnicity? As the author of the study notes, appearance and race specifically function as a proxy for nationality among immigration officials. In these Dutch studies, race operated as a proxy for nationality, even though the data collected by the enforcement agencies actually showed that the greatest proportion of drivers stopped were ultimately Dutch. In other words, race was not a reliable proxy for nationality or documented status, even though it was so heavily relied upon by these immigration officials. Although the majority of individuals stocked were Dutch, most did not fit the officer's description of a Dutch person because they were not white. As you will no doubt be discussing, this is a dynamic that has prevalence across the European Union, notwithstanding my focus on studies from one country. The urgency of a seminar like this that you are all participating in is to explore the ways in which existing laws and changes to existing laws can acknowledge and respect the full humanity of racially and ethnically marginalized communities. For too long, traditional human rights advocacy, especially legal advocacy, has neglected racial injustice and discrimination, especially where this discrimination is embedded in neutral-seeming categories and distinctions, such as the distinction between citizens and non-citizens, documented and undocumented, and so on. But I think it's also important that a seminar such as this be situated within the broader context of the colonial and neo-colonial racial injustices that are embedded in the border and immigration policy of the European Union. In her book, Bordering Britain, Nadine El-Nani writes, and I'm quoting here, "It is through immigration's laws, policies of access," let me read that again. She says, "It is through immigration laws' policing of access to colonial spoils that the racial project of capitalist accumulation is maintained, a project which she argues is legitimized through judicial rulings in immigration and asylum cases." In her book, El-Nani powerfully highlights how Britain's immigration laws play a part in maintaining colonialism's global racial order, according to which racialized populations are disproportionately deprived of access to resources, healthcare, safety, and opportunity. I highly recommend her book as an essential reading, especially for lawyers who are working in the field of migration. She details the role of immigration law in controlling access to what she describes as the spoils of empire. Britain is no longer a part of the European Union, but this union remains one that has as its center the former colonial nations that developed global racial hierarchies and relied upon them to plunder, but also deeply to interconnect peoples and territories outside of Europe. In my own academic work, I've highlighted how one of the characteristic features of European colonialism was migration laws and policies that privileged and facilitated the international migration and colonial settlement of white Europeans in the rest of the world, especially to Africa, America, the Americas, Asia, and the Pacific. Today, Europe's borders are tailored to exclude and punish the very peoples to whom it owes colonial and neo-colonial debts that it has never repaid, the communities and individuals subject to the most punitive racialized policing and border enforcement actions in Europe, who are typically cast as presumptive criminals or outsiders who do not belong. In many cases, these people are political and economic compatriots that Europe itself generated through its imperial ambitions. Racial profiling is not only a human rights concern, it's a global justice concern. I want to close by again thanking the organizers for including me in this really important event and by expressing my profound regret that I cannot be there in Brussels or participate live in this important seminar. And I wish you a productive time together. Thank you very much.
Following this great introduction, I think, to our legal seminar, I'd like to welcome the first panel to the stage. So if you can slowly come, we'll be looking at basically the EU migration policies through the racial justice lens. So I invite Emmanuel Achiri. He's the Migration and Policing Advocacy Officer at the European Network Against Racism. He is co-founder of Voice Cyprus, a migrant-led organization in Cyprus, and he recently completed his PhD in international relations, which focused on critiquing the principle of voluntary repatriation. And we're also joined, he'll be joined in person by Karin de Vries from the Utrecht University, Alyna Smith from PICUM, Eleftheriou from DG Home from the European Commission. And online, we're joined by Vida Beresneviciute from the European Union Agency for Fundamental Rights. And I'm just going to highlight again, if you need the interpretation, we do have here the remote, the headsets. Pour ceux qui ont besoin d'interprétation, on a tout le système ici. Je ne sais pas si quelqu'un a besoin, mais vous pouvez encore prendre en français et en espagnol. I can't say this in Spanish, actually, so hopefully nobody needs it in Spanish in person. Yeah, there we go.
Thank you very much, Louise and PICUM, and of course for organizing this very pertinent and important seminar and discussion on migration and racism in Europe, and of course to our participants joining online. Thank you for joining, and for those of you who are here as well, it's a pleasure. The objective of this panel basically is to better understand EU migration policies from the lens of racial justice, including a historical and colonial dimensions, as our keynote speaker mentioned earlier, and also as mentioned by Dr. Alpa Palmer, borders are mirrors, and borders are mirrors that reflect and represent exclusionary attitudes and racialized anxieties. One could also make the same argument that the new pact on migration, which in a week's time may be finalized at the trialogues, is a technology of race making that reflects the anti-immigrant discourse and attitudes in Europe, and is designed to stop people who do not fit imaginary stereotypes of race and whiteness. To understand how we have gotten here, it is important for us to adopt a holistic approach, understanding the historical and colonial dimensions, applying an intersectional approach, and deconstructing the securitization of migrants. And with me on this panel today, we have Karin, the Vries. We also have Vida, who is joining us online, and I hope is there. She's there. All right. Amazing. We also have Eleftherios, and we have Alyna. Welcome. I would start with Karin. So Karin is an associate professor of constitutional law at Utrecht University. Her principal research interest is in non-discrimination law with a focus on racial discrimination against migrants and migrant communities. Karin, in your article, Race and the Regulation of International Migration, you argue that the European Court of Human Rights approach to migration and racial discrimination fits a pattern in the historical development of migration law, whereby the right to travel and the power of states to restrict these rights have been consistently defined in such a way as to protect the interests of the predominantly white population of today's global north. You're also here to provide us an overview of this historical context, as well as case laws from the European Court of Human Rights and the European Union Court of Justice. Welcome.
Thank you. Thank you. First of all, I apologize. I have a very bad cough, and I've noticed that the more I try to suppress it, the worse it gets. So I hope it won't bother you too much during the presentations. The article that you mentioned, Emmanuel, was co-authored with Thomas Spijkerboer. I'd just like to mention that it was a co-production. And if in the presentation that I will give, would it be possible to get the presentation on the screen? If you recognize some of the things that were just mentioned in the keynote by Tendayi Achiume, it's because her academic work has been very inspirational to my own. Thank you. So I've been asked to speak on EU migration policy and law from the perspective of racial justice, and I'll try to set out some key points in a maximum of 10 minutes. And the main point that I want to make today, thank you, is that although EU migration policy is not explicitly based on race, it nevertheless contributes to creating and maintaining racialized distinctions, and that between the people who are excluded and those who are forced to live in the European Union in precarious circumstances due to not having a secure resident status, people of color are overrepresented. And I will try to shed some light on the mechanisms, especially the legal mechanisms that make this happen. Nope. Oh, hold on. It's not on. Nope.
It works. Yeah. It works. Maybe flip it back.
Here we are. Yes, thank you. I think it's okay. Thank you. Thank you very much. Right. So very briefly at first, what is EU migration policy and what does it do? I've mentioned on a slide some of the competences of EU migration policy that I consider together to form its principal elements. So it's about controlling external borders, about controlling who gets into the Union, and about deciding who is eligible to enter EU territory, whether that is for the purpose of international protection or for other migration purposes. And it is about keeping out those who are not considered eligible. And all of these competences are manifestations of an underlying doctrine of international law that we refer to in the article as the doctrine of sovereign migration control, and which entails that states have a sovereign power to decide who gets to enter their territory. So what we see here is the power of the member states under international law as transferred to the European Union, to which they voluntarily acceded, to decide who gets to come into the European Union legally and who doesn't. So what does race have to do with this? What I will try to show is that this doctrine of sovereign migration control is not, in fact, a neutral doctrine. It was devised historically with the specific purpose of being able to select immigrants on the ground of their skin color and to restrict entry to those who are considered undesirable, that is, who are not white. And I will try to show how even today, formally neutral immigration rules, not explicitly based on race, continue to keep in place this racialized pattern. I don't have the magic touch. Thank you. Or maybe I'm just too impatient. That's also possible. Okay. So this doctrine of sovereign migration control, the idea that states have the right to control entry into their territories, that has not always been considered an inherent element of statehood. And in fact, it originates in a series of judgments by the United States Supreme Court that were given at the end of the 19th century and that have become known as the Chinese exclusion cases. And before this time, in fact, the prevailing doctrine in international law was that there was a right of free movement between states, that people had as a natural right, a human right, the right to move across territory, to move to different states. And it is that doctrine that served in previous centuries to justify the movement of Europeans across the world, and in that way enabled colonial expansion, including settler colonialism in the United States. At the time of these judgments, however, at the time of these Chinese exclusion cases, the direction of migration had reversed. The US was in need of labor and it sought to bring in people, especially from China and Japan, to fill its labor shortage. This nevertheless caused concern among the dominantly white population about the integration of these people, about them not being suited to living in a predominantly white society that the US considered itself to be. And this is where the United States Supreme Court formulated the doctrine of migration control in explicitly racial terms. So it held that the US government, as a matter of sovereign power, could exclude foreigners of a different race who will not assimilate with us. So the latter is a quote. This doctrine subsequently spread to other countries, first predominantly other settler colonies, but a century later was also adopted by the European Court of Human Rights in the first major ruling, its first major ruling on immigration, the case of Abdulaziz Cabales and Balkan Dali. And the applicants in this case were three women who were living in the UK and who sought family reunification with their husbands who were living abroad. And they argued, amongst other things, that the UK immigration policy, which kept these husbands out, was racially discriminatory because it had the effect of excluding far more non-white migrants than white people. And at the time, this was after the Second World War, the International Bill of Rights had been adopted. The prohibition of racial discrimination had become a cornerstone of the international human rights regime. And so it was no longer acceptable for self-proclaimed human rights respecting states to explicitly distinguish between migrants on the ground of race, as it had been at the time of the Chinese exclusion cases. And this was also acknowledged by the European Court of Human Rights, who said in this judgment that states cannot adopt a purely racist migration policy. However, it did not find in this case that the UK immigration policy in fact amounted to such a racist policy. And it considered that the fact that the policy, as it did acknowledge, affected many more non-white migrants was a matter of contingency, did not make this into a racially discriminatory policy. And so there is a sort of dual bias, dual denial, if you wish, in this judgment. So on the first hand, the denial that the policy was racially discriminatory for, in effect, excluding mostly non-white migrants, but also a denial of the colonial history that had led up to the judgment. The court held that states may give preference to countries with which they have close ties. However, it accepted the UK argument that it did not have close ties with countries such as Pakistan, which until only a few decades earlier had been for centuries under UK colonial rule. So this judgment shows that the European Court of Human Rights allows EU member states and other member states of the Council of Europe to regulate migration in a way that denies the effects of such regulations on immigrants of color and denies the history of several EU member states as former colonial powers, as long as the policies do not take on an explicitly racist character. So as a final step, I would like to mention some of the ways in which current EU migration policy, so even though not being explicitly racist, nevertheless continues to create racialized distinctions. And the first, I think, most obvious mechanism, if you wish, is through its visa policy. The EU has visa lists, which decides who needs a visa to come into the European Union and who does not. And if we look at these lists, it is obvious that most countries in Africa and Asia with predominantly non-white populations are on the list of people who need a visa, whereas on the other hand, it is mostly majority white countries, including Canada, the United States, Australia, and New Zealand, that are exempted from that visa obligation. And whereas, of course, these visa lists apply only to short-term migration, that actually constitutes a substantial share of global migration, and for many people represents an important way of actually entering the EU. Still, if we also look at the long-term migration policy, we see that here again, although the conditions for long-term residence, as they're stated in the Family Reunification Directive, the Blue Card Directive, the Long-Term Residence Directive, are formally neutral as regards race. But many of those conditions, if we look at income requirements, requirements in the field of education, even culturally loaded integration policies, will be much more difficult to meet for large parts of the populations in majority non-white countries. So there's again that indirect racialized effect. Also, in these same directives on long-term residence, we do see that there is sometimes room for member states to differentiate within the framework of the directives. And this discretionary room does get used by member states to apply policies that are applied differentially to people of different nationalities. And the Netherlands constitutes a prime example, having an integration policy that requires non-Western foreigners, people with non-Western nationalities, to succeed in an integration exam before they are allowed to enter for family reunification, whereas this is not asked of American citizens and other countries considered to be Western. Finally, however, perhaps one of the major mechanisms is perhaps not so much a mechanism at all, but rather the inequality in starting positions that we must consider. If we look at the way that wealth is currently distributed across the world and across countries, it should be clear that people in many predominantly non-white countries have a much greater interest in migrating to the EU and other developed states where the jobs are, where economic chances are to be had, where life standards generally are higher. So even if exactly the same non-differential migration policies applied to everyone, it would still be more detrimental to people who need to migrate in order to improve their life chances, at least as long as nothing is forthcoming from the other side. And let's not forget, as Tendayi Achiume also mentioned, that this unequal distribution of wealth across the globe is, of course, very much a result of former colonialism. So I will leave it at this. I very much look forward to hearing the other speakers and getting your comments and questions.
Thank you very much, Karin, for this succinct overview, of course, which highlights, the colonial, the racial, but also the contemporary practices and the decisions by the courts. I'm sure that towards the end, there are going to be probably some questions for you, so we'll leave that for the end. I would just like to remind our audience online, but also those in person as well, that if you have questions, please maybe you start sharing this with the organizers for those who are online in the chat section. And I think that your presentation was really quite indicative of the problem that we have today with migration in Europe, or at least the racial elements. And I think that also indicative of this is the recent report that was published by the Fundamental Rights Association on being Black in the European Union. And our next speaker is actually Vida, who is project manager at the Equality, Roma, Social Rights Unit at the EU Agency of Fundamental Rights. And we'll be presenting selected findings of this report.
Hello, everybody. I'm trying to share my screen. It takes a bit of time. Yeah. I hope just a second. It should. Can you see it?
Yes.
Yeah, it does not, for me, it does not appear in a bigger size, but although I'm trying to. Yeah, here it is. Many thanks for possibility to present shortly the findings of our recently published report and to contribute to the legal discussions. Before I present shortly some selected key findings that fit the agenda of the seminar, I would like to say just a few words about on the basis of what we are presenting. I will be presenting the data. So the recent report, Being Black in the EU Experiences of People of African Descent, is actually a subsample of third EU survey on immigrants and descendants of immigrants that the agency has just completed in last year, in 2022. It analyzes over 6,700 persons of African descent across 13 EU member states. Here they are listed, just maybe to mention that these countries are home of the majority of the population of African descent across the whole EU. The respondents originate from 54 different countries of origin, most often from Nigeria, Somalia, Senegal, Ghana, and Angola. And of course, these countries vary across the EU countries surveyed. Maybe worth mentioning that the majority of respondents are born outside the EU, hence we define them as immigrants, it's 86%, and the rest are descendants of immigrants who are born within EU, and some other characteristics are on the screen. The report covers a lot of different topics and areas like experience of discrimination, hate crime, police stops, but as well as socioeconomic situation and living conditions, which we also try to give comparison to the general population of the countries covered. The report also includes, along the key findings, the opinions, which refer to the ways forward to tackle the issues that we see and we raise in the report. And of course, some technical information about the report. So let me move to some selected key findings. What do we see from the responses of the respondents? So since we have the data from the previous survey, from the survey in 2016, we see that racial discrimination has increased in key areas of life. As for example, 5-year prevalence, it means that in the last 5 years, 45% of respondents of African descent said that they have experienced racial discrimination in one or more areas of life. This percentage share in 2016 was 39. These incidents of discrimination are not individual or isolated incidents. They are reoccurring. Most of respondents have multiple experiences and cumulative experiences over time and across different areas of life, with employment and housing outstanding with the highest prevalence rates for racial discrimination. However, most incidents are not reported to any organization. According to the survey data, close to 9 in 10 respondents, 9% who felt discriminated, reported any incident to any institutions. Similarly, as racial discrimination, race-based harassment remains widespread and unreported. It remains invisible to institutions with a legal obligation to help the victims. So with regard to the 5 years before the survey, nearly every third respondent, a person of African descent, said that they have experienced one or more racist incident. And in 12 months, it's nearly 1/4. Of course, these numbers vary across the countries covered, and in some countries, the numbers get even higher. But this is, that is maybe, I will not go into the details, taking the time concern. Maybe worth mentioning that although most of the perpetrators in the racist harassment incidents remain unknown to the victims, they can't identify, or they say that they do not know them, still some 3% of victims mentioned police officers and border guards as perpetrators of the most recent harassment incident. Of course, these numbers are too low to make any elaborations on the country level, but still this is the experience. And it also linked to the experience with regard to police stops that people have experienced as according to the survey. And we see that, the police stops remain involving racial profiling. Although worth mentioning that the police stops rate is much more lower than with the previous survey, and this is just because the survey, the data collection did fall into the different waves of COVID, and people were not able to move freely as they would have been done several years ago. So 12% of respondents were stopped by the police, and most often it has happened in a car, like 40% of the cases, on the street, also 38%, but as well as on the public transport, again in some countries with some higher percentage. As the survey data show, younger respondents tend to be at higher risk to be stopped. We also ask, what do the police ask or do during this police stop? So in most cases, people say that they were asked for identity papers, or that the police officers asked for various questions. So just to give you some numbers as an example, 72% said that they were asked for identity papers, 59% asked various questions, compared with 11% of those who got fined, or 7% who have been taken to the police station. But when we ask if the most recent police stop was perceived as racial profiling, the numbers turn significantly, and they are significantly high. The majority, according to the survey data, 58%, of those who have been stopped in the last year, in the 12 months before the survey, they perceive and they characterize the most recent stop as racial profiling. What we else see based on the survey results, and this is also in relation both to racial discrimination, racist harassment, but more specifically with regard to the police stop, that those who perceive the police stop as racial profiling trust the police much less. And this is, of course, has an impact on their behavior. So just to finish my short presentation, it's like the circumstances of the police stop and the perceptions, they suggest that that people perceive being stopped rather not because of their behavior, but just of the color of their skin. I have some data on the country level, but I'm conscious about the time and the request from organizers to be short and concise, so I can keep it for later questions if needed.
Thank you very much, Vida, for keeping to time, but also for this, the presentation of the findings of this report. I think we can all agree that it is very concerning, the increase from 39% to 45% of experiences of racial discrimination amongst people of African descent, but also the fact that almost 58% considered like police stops as part of racial profiling. And I think it also fits into some of the findings of the review of the Racial Equality Directive, which was done a couple of years ago, which basically highlighted that one of the major gaps of the Racial Equality Directive was discrimination by law enforcement, including border officials in this case. And I think this brings me as well to our next speaker, because the EU Action Plan Against Racism was basically put in place to address racism and discrimination in Europe. And our next speaker, Eleftherios, is the Equality Coordinator on Migration and Home Affairs and a member of the Task Force on Equality of Commissioner Dalli. Eleftherios, I would like to basically pose two questions to you. One is your thoughts on the EU Action Plan Against Racism, and then even more specifically as well, how this plan on the Action Plan Against Racism is incorporated into the work of DG Home. Thank you.
I would like to set up a little bit the environment where this equality fits in the Commission. So I'm going to start from the President of the European Commission, the von der Leyen Commission, who has had quite a lot of innovations in her term. One of these, and very relevant for us today, is the creation of a separate equality dossier that it was not before in the College of the European Union as a specific dossier. So the equality dossier is created, and the role of the Commissioner has been entrusted to Elena Dalli. And Elena Dalli is responsible of following every equality aspect in the European Union. So for us, a new era started in the protection of equality, not that we didn't have before, but the policies were spread around in the different directorates, and now are all under the Equality Commissioner. For the purposes of implementing the mainstreaming on equality, another innovative idea was adopted. And that was based on the idea that equality has to be mainstreamed through all policies. It is not one policy. If I am allowed to say it so, it is a policy that of every policy in the European Union. In order to tackle this, the European Union created the Task Force of Equality. And the Task Force of Equality is composed by one coordinator in each directorate of the European Commission. This is the role that I have been entrusted in DG Home to be the equality coordinator in the policy field of migration and security. This task force is responsible for ensuring that the equality principle is implemented, and the most important one, to build up expertise in all areas that we have not tackled. When it comes now to racism, in the 18th of September 2022, the European Commission adopted the very ambitious EU Anti-Racism Action Plan that sets out a series of measures over the course of the 5 years. These measures cover a comprehensive range of policy areas, including, among other things, the employment, digitalization, media, youth, education, migration, of course, and in my DG, the area which is more visible over there is in the security area, the home affairs area. The European Commission is, through this action plan, it's strongly encouraging the member states to develop and adapt national action plans against racism and racial discrimination. And we will closely involve the civil society and equality bodies in this. To support the member states in their efforts, in March 2021, the Commission established a subgroup of member states experts which elaborate common guidelines principles required to protect effective national action plans against racism and racial discrimination. That was a very important step to include the member states in this process, and the guidelines were officially published in March 2021. Of course, the most important aspect of the action plan was that a commission coordinator on combating racism was previewed. And in 2020, the Commission, when it adopted this action plan, immediately put in motion the mechanism in order to appoint the coordinator combating racism. My very dear colleague, Michele, is the first ever coordinator on combating racism, and her role is to liaise closely with people with minority racial or ethnic background and relay their concerns to the Commission. The coordinator interacts with member states in European Parliament, civil society, academia. She is trying to strengthen policies responses in the field of anti-racism. What I wanted to note about this action plan is that it is a living instrument in the sense that it may contain actions, but these are not the only ones. We are bound, as me as equality coordinator, but every desk officer in every DG, in every policy area of the European Union, we are bound to be open in any given opportunity to mainstream equality, mainstream anti-racist measure in all of the legislation and policy. I covered now the anti-racism action plan, the coordinator. When it comes to DG Home, the actions that you can find in the anti-racism action plan have to do with mostly with the integration of migrants. I don't know if you want me at this part to dwell on this, or shall we leave it on a separate, because we can have quite a lot of discussion on the integration. Then I would like to mention also the online spaces and the threats that people of ethnic origin or other religions may face. We are having in DG Home measures that we're covering this area as well. So, but also, and this one of my great interest is that we are having in the DG Home the competence to have a say on the protection of places of worship, one of the most important, I suppose, parts of integration and inclusion. And then I would have liked to mention the funds that the European Union is having on the asylum integration and migration funds that we can have in these funds, tailor-made projects that they can be developed for combating racism. I think I am within my time limit. Thank you very much.
Thank you. Thank you very much, Eleftherios, for presenting this brief overview of the EU action plan, and also some of the work that DG Home is doing, or how DG Home is integrating the action plan in your work. I'm sure during the question and answer sessions, perhaps there'll be some more pertinent questions about some of the specific things that your office is doing with regards to this. Now, as a segue into our next speaker, Alyna, Karin mentioned or spoke about, the historical and colonial context of migration and racism, and of course, as well, Vida gave us a presentation about the FRA report and the prevalence of racism, and then, of course, as well, we see that the EU Action Plan Against Racism attempts in some respects to make reference to migration, not in its entirety. And so it's really important, at least for us, to understand, or at least what PICUM or how PICUM puts it, the approach to migration, which from the perspective of PICUM is informed by the criminal justice logic, and breadth, we could say the securitization of migrants as threats. And as deputy director at PICUM, and as someone who has been a focal point on digital rights and migration, I would really like for you to take a few minutes to perhaps explain to us the intersectionality of the work that PICUM is doing, but also the approach with regards to migration. Thank you.
Thank you very much, Emmanuel. So indeed, my role, I guess, is to bookend the panel, and I'll in fact be echoing a lot of what we heard at the very beginning from Karin, but from maybe bringing some additional kind of perspectives and observations from our work at PICUM. And indeed, as was also mentioned by our keynote, of course, our work is very much centered on undocumented people and people who have an insecure status. But of course, we're not reductive. We don't see that our work is centered on questions of status, because of course, exclusion and the experiences of people in those situations are very much tied to intersecting factors that very much touch on what we're discussing today. So kind of there are two dimensions I wanted to unpack a little bit together in terms of how racism informs, on the one hand, immigration enforcement policies, and on the other hand, as we also heard a little bit at the outset from Karin and from Achiume, from Tendayi Achiume, who even has the opportunity or the possibility to have freedom of movement and mobility. So in terms of immigration enforcement, I think it's saying something maybe a bit obvious to everyone in the room, that the dominant approach has very much and is very much informed, as you mentioned at the outset, by notions of risk and threat. This is something we routinely see in discussions of migration as a broad concept. So in political contexts, or shall we say populist discussions, and also in the media, I was reading a quote from Geert Wilders, who recently had so much success in the Dutch elections. And he said in this quote, "The Netherlands has hope the people of the Netherlands will get their country back, and the tsunami of refugees and immigrants will be limited." So this driving kind of background of threat, of limiting and restraining threat and risk, of course, is imbued with racist and xenophobic undertones that I think we need to recognize from the outset. And I think one thing I wanted to really maybe focus on a little bit is that this is not only a question of how we see conversations happening in these spaces, of narratives in certain spaces, but we also see that reflected in the tools and the logic of the criminal legal system reflected in immigration enforcement. So that includes the role of law enforcement also in immigration enforcement. We see this, of course, in the language even of the treaties, which refers, it's very much around deterrence. We see a focus on preventing and combating irregular migration. We see this in the fact that, as the Vries pointed out in its 2014 study, that 16 of 27 member states, people entering or staying irregularly face potential imprisonment or criminal fines. And we see this in the way we approach assistance to documented people, which is criminalized under the Facilitation Directive, which obliges member states to punish people who intentionally offer assistance to people who are moving or transiting irregularly through a member state. We see it even in the way that we justify, in terms of protection, approaches that actually create harm. So we see counter-smuggling measures, which are ostensibly about, in part at least, protection, that actually tend to be used against migrants themselves, that actually make crossings less safe, create environments that are hostile to them, and deter solidarity with them. We see this in the anti-trafficking framework, which again is ostensibly one that is around protection, but actually is often used to give additional political justification to measures that prevent and sanction forms of migration. that justify raids on workplaces to identify people who have been trafficked, including so-called rescue operations for sex workers, which often lead to undocumented people not being assisted, but arrested, detained, and facing deportation, deprivation of their earnings, and rather than access to justice. So, and I think we see in a way, maybe the most clearly, that one of the pillars of the immigration enforcement kind of toolbox is deprivation of liberty, which is, of course, centrally borrowed from the criminal justice or the criminal legal framework, but of course, in the immigration context, without all of the accompanying safeguards for the people concerned. And we see the apparatus also of surveillance, and as I'll come to in a moment, and we've already heard, of profiling being very much a driver of how we conduct immigration enforcement. And also using the justifications of addressing crimes, addressing security threats as a basis on which to actually curtail the fundamental rights of non-citizens. So actually to circumvent the rights and the standards that the EU actually itself is intended to uphold. I think, so briefly, I wanted to speak about this question of profiling, which we'll get into much more in depth tomorrow. And of course, we all know that ID checks are a central feature of the EU migration policy, and that these happen routinely at borders, in airports, but also in our communities. And this is where we come to the role also of law enforcement and immigration enforcement. And of course, this is part of a strategy of identifying people who might have not be using their own documents, and also to scale up deportations. And we see, as we'll come to in later discussions today, also speaking of the apparatus of law enforcement, we see the use of technology very often, increasingly used in the context of identification, including biometrics, so fingerprints, facial scanning, to do this kind of identification. And as we've already heard, we heard from our keynote as well, in the context of law enforcement and migration enforcement, very often race, ethnicity, and skin color are viewed as a kind of stand-in, a proxy for a person's migration status. The FRA also reported on this in 2014, that 79% of surveyed border guards at airport rated ethnicity as a helpful indicator to identify people attempting to enter irregularly. I also wanted to mention that, criminalization and profiling in the migration control can also and does also interact with other forms of criminalization, for example, of sex work. So we see in Sweden, Norway, and Finland that non-EU citizens often face or do face deportation and denial of entry if they're suspected, quote unquote, of selling or intending to sell sex. So these laws essentially give more power to the police to surveil and harass sex workers, particularly those who look foreign. And so in Finland, this has reportedly led to the police in some cases targeting women they perceive to be migrants, regardless of their citizenship status. And I think this speaks to the ways in which immigration enforcement, racial profiling, and these various kind of tools that are used for immigration control are not only affecting non-citizens, but it's also affecting anyone who potentially looks like non-citizens, so racialized people within our communities. So the last thing I wanted to just briefly say, and it speaks again to what we heard earlier, is also understanding like this question of beyond immigration enforcement, how do we understand kind of racism within the frame of who even can enter, who even can exercise freedom of movement and mobility. We already heard about the 104, I think it is, nationalities of people who need to actually apply for a visa to enter the Schengen area, the vast majority of whom are concentrated in Asia and Africa. And I also wanted to mention the rules around who can migrate for work. And this is something that's very much a cornerstone of PICUM's work, and that national migration policies across Europe continue to offer decent labor migration opportunities, mainly to workers who can obtain highly paid employment or for very, very specific skill shortages. So by and large, accessible, decent working opportunities and labor pathways across a range of occupations remain very, very limited despite the demand of the labor market. So this speaks a little bit to what we were hearing about before. So who has the opportunity to come here to work? And once they're here, who has the opportunity to work in a context that's actually decent and fair, where their rights are properly and fully acknowledged? So I think it's really important in that context that we really understand the need for an intersectional approach and understanding to the various systems of oppression that affect people in terms of the sharp end of immigration control, but also in terms of, we heard before, even the opportunity to come, to enter as a visitor, or to enter and to work under decent conditions. So maybe I'll leave it there.
Thank you very much, Alyna. I think we can all agree as well that, as you rightly mentioned, that because migration to Europe principally has been securitized, this is reflected in the different practices by member states, but also the institution. And I mean, one could as well say that the new pact on migration, which has been agreed, exacerbates a lot of this. And before I take questions from the audience, I would also just want to give people a couple of, I think we have maybe like 7 minutes, give or take. Okay, so like 5 minutes, give or take. So I would ask the first question, and then I would open it to the audience for 2-3 questions. And from the online team, I'm not sure. Okay, I've noted down 2 questions as well from the online team, or from the online audience. And my first question is to the panelists, and please, if you could take like 30 seconds each to just very highlight only what is really very pertinent. And I really want us to bring this discussion into what is at stake today, which is a new pact on migration, because the trilogues are coming up on the 6th and the 7th, and potentially on the 16th and the 17th. And I would like to hear from your perspectives how you think, or if you think, that this new pact on migration racializes migration to Europe. Perhaps I'll start with you, Karin.
In 30 seconds, I'll try to connect a few, oh, sorry, thank you. A few dots, no, 2 dots. We've heard, Alyna, you mentioned it, and Tendayi Achiume mentioned it as well, about racial profiling, how ethnicity or skin color is used as a proxy for lawful resident status, and how, of course, that is inadequate in diverse societies such as the Netherlands. However, I would like to add that is, while that is true, of course, in the opposite, it is very adequate if we consider how migration policy has been shaped to exclude people from predominantly non-white countries, right? So it will not tell you who is a citizen, but it will, to a large extent, tell you who is not a citizen, because that is how we have structured migration law. And I think if we want to comment on the EU migration policy, that is something we really need to take into account. It's very deep into the structure of EU migration policy.
Okay. Thank you. Would like to go next. Vida as well, if you would like to, but is any of the panelists also willing to comment on this?
Just as a matter of reference, and this will be the only legal thing that I will be offering today, is that I'm very concerned about the ethnic profiling. Nevertheless, and we've heard a reality that I have also lived in my life, I've faced it. If it is of any comfort, it's that I would like to mention that the Schengen Borders Code, as well as the Visa Code, they do have some guarantees of protection of fundamental rights in respect of this. So the conduct of border checks should always be in full respect of human dignity, and they should not discriminate against any kind of discrimination, including race. So there is a legal basis on that. After that, it's humans that they are implementing it. And yes, it's true that sometimes reality is beyond us.
I will be very brief because I think we're going to dig into this a little bit, in the next panel or tomorrow. We'll hear specifically about some of the pact files. I think maybe just one thing that we've seen that has been kind of further entrenched in these negotiations is this notion that there's really only two options. There's potentially asylum and then there's return, and not an acknowledgement of the multiplicity of spaces in between, where people can actually, where there are opportunities to have status. And just also it reflects a very binary, reductive way of understanding a very complex reality. So we've seen a further entrenchment again of this asylum on the one hand, unfortunately, arguably also like problematic approaches to asylum, but on the other hand, really, again, like doubling down on the return dimension as really the primary, if not the singular kind of alternative, if you will, to asylum.
Thank you. Are there any questions from the audience? Yes, please. All right. There is a question over there. Yep.
May I ask my question in French, or I can try in English?
I think you can ask in French as well.
Ok. En fait, ici en Belgique, on a constaté
here in Belgium, they opened the possibility for Ukrainians to come here. So there was a European directive allowing Ukrainian people to come here, but at the same time, we prevented Ukrainian inhabitants who were foreign students mainly to flee at the same time. And I would like to know what is the justification used for that, because in my view, this was a racial justification, because when bombs starting to fall on Kiev, the danger was exactly the same for Ukrainian inhabitants or foreign students coming from Africa. And the directive prevented African students, there were many African students in Ukraine, to come here. They didn't have the same possibility to flee to Europe. And I really did not understand how it was possible to justify this within the EU.
It was in DG Home that we had the temporary protection directive about Ukraine, and it was based on the nationality. And it's true that some incidents like this happened there in the implementation of the temporary directive. So it is based on the nationality. That's why this happened. Yeah.
All right, thank you. I mean, just for the audience, perhaps for those who do not understand the question, it was basically a question about the temporary protection directive that was put in place for Ukrainian refugees, and why there was a prohibition for non-Ukrainians who lived in Ukraine from also benefiting from the temporary protection directive, and why or how this could be justified by EU member states, but specifically in your case about Belgium. All right, I don't know if any of the other panelists wants to react to this. All right, okay, I think just one last question, because your hand has been raised, but then we have to close the panel, sorry.
Hi, I'm Julia from the Migrants' Rights Network. I very quickly, I heard the word integration mentioned a lot in the panel. And as an organization that delivers anti-oppression language training across the UK and starting in Europe, one thing that we've started to kind of hear a lot of from our network and our staff body is actually the term integration is actually inherently quite a damaging one. And the idea of integration is quite a damaging one, because what it ultimately expects mainly racialized people in the West to do is perform whiteness and be forcefully assimilated into a system that is designed and does oppress them, and has arguably caused the push factors from which they are fleeing from. So I guess my question is, this emphasis on integration being the solution, is integration actually just another mechanism of enforcing internal borders?
I will leave that for our panelists. 20 seconds each. I know it's very hard to say anything in 20 seconds, but yeah.
That is very kind. Thank you. So 40 seconds. I think this is a trend that has been ongoing, and being from the Netherlands, where this has started, I think almost 20 years ago now, of integration being formulated as a requirement that people have had to meet to be able to enter the territory. But other countries, Denmark, Austria, Germany, the UK, France, have picked up on this. So I think that's definitely there. And as with all of these words, of course, it's not necessarily in the term itself, but it is definitely being used in that way. And perhaps just to add to what you're saying, yes, to exclude, to force people to assimilate, but while at the same time, I think carrying out the message that you will never quite succeed, right, in being like us. So a sort of double exclusion.
Last words from Alyna.
We agree. I agree.
All right. Thank you very much to all of our panelists, to Karin, Vida, Eleftherios, and Alyna, and also to the members of the audience, both online and in person. And I hope that you can also meet the panelists during the break and ask other pertinent questions. Thank you.
So thank you for like this. Thank you for coming back so quickly in the room. We're now going to start with the next part of our legal seminar, and we're delving into more closely into the sort of intersection between criminal and immigration law. So we're very pleased to have this brilliant panel with us. The discussion will be moderated by Laurence Meyer. She's a lawyer. I'm sorry, I'm reading the wrong word. She has a master in European Comparative Public Law from the Sorbonne University in Paris. She's a jurist and currently works as racial and social justice lead at the European Digital Freedom Fund, and she co-leads the Decolonizing the Digital Rights field process jointly with EDRi, and leads the Digital Rights for All initiative. She's part of the magazine ASGI and co-founder of the apologies, film festival dedicated to Afro-descendant women and non-binary filmmakers in France. She works on issues of digital rights and notions of race in law, and has written articles on these topics for French and German newspapers. So welcome, and I leave the discussion now to you.
Press, and also very happy to learn about technology as we go. So yeah, very happy to be here to talk about this important subject. I think a lot of the matters that we're going to dive into have been touched upon in the preceding panel, and I think that's great to see a coherence in how we approach the question of migration and how we approach it as a oppressive legal framework and a tool of oppression. And so when we talk about the criminalization of migration, and when we talk about blurring the line between those two, we have to understand how it comes to be, right? We have to understand it as a way of shifting a framework that creates people, that see people as deserving of safety, to a framework that creates people as actually a threat to safety. And that is basically how people in migration, people on the move are being treated currently in Europe, and not all migrants, but specific ones, mostly people coming from the global south, so from former colonies of Europe. And that shift in the paradigm just allows two things, right? It allows to create discriminatory legal frameworks, but it also allows discriminatory enforcement of those discriminatory frameworks. So a double form of discrimination. I think one of the good examples is just like looking at the panel that we are, and I think we all have a story of immigration here. And we, I think, are all like holders of European passports, but the way we experience crossing borders are very different. And we do understand by that those rules have at their core racial and therefore racist functions and impacts. So I'm very happy that we're going to talk about that, specifically in that moment where a lot of people, racialized people, people that have a history of migration are mobilizing for a free Palestine and are actually also really much having to bear the consequences of it and having to understand very cruelly the double standards under, to which they are held. And I'm thinking just about people liking posts and posting on social media and losing their job, and that leading them to probably lose their residency status. So very, very important topic that we're talking about today. And so to do so, really happy to have great experts. And if I can open my phone, we will know what they are doing. Ulrich Stege is an International University of Turin faculty member, director of the IUC Clinical Legal Education Program. Beside his role at the IUC, he is practicing as a qualified lawyer in Italy and Germany. He is a founding member and executive secretary of ENCLE, European Network for Clinical Legal Education, and a member of the steering committee of the GAJ, and member of the Italian Law Clinic Network, ASGI, and the Migration Law Network. So very active in a lot of network. We love seeing that. Chloe Berthelemy. Chloe leads EDRi's policy work and law enforcement and data protection issues on law enforcement and data protection issues, including EU police and migration databases and information exchange frameworks. EDRi, European Digital Rights, is the largest European network for NGOs working to promote and defend human rights in the digital era. Silvia Carta is an advocacy officer at PICUM. She previously worked on migration and asylum policy in a Brussels-based think tank and the European Parliament and at the UN Refugee Agency. She has a background in international relations and human rights governance, and she holds a LLM and in EU law. So now that we know who are the suspects of our investigation, happy to move to you, Ulrich, and see a bit what are we meant to understand when we talk about criminalization and the blurring the line between migration law and immigration law and criminal law? And the floor is yours.
Thank you, Laurence. And thank you very much, PICUM, for organizing this very important meeting. I think it's very important to start not only talking about the different effects of the immigration policies, but really talking about the problematics of racist approach that also inside of our policies. And I think that's very, very important what you're doing. First, maybe you can.
I think you need to use
this. Okay, perfect. It's loading. Okay, cool. This is just a publicity of the project. I'm part of the Association of Juridical Studies on Immigration, doing quite a lot, especially also on trying at least going into the subject of racial profiling and so on. So have a look on this project ASGI Medea, what we're doing. I want to, as a next, just going into more generally in the subject of blurring the lines between administrative and criminal law on the topic of migration. And you can see here a number of trends that have been in the last, I think, 10 to 15, even more years into the European scene and also a policy that basically three kind of particular cases that I think are important to highlight. First off is the use of administrative detention for security-related purposes. But secondly, there's the criminal law as a sort of management tool for migration that has been used. and we will all kind of address these issues in particular in this panel, and the use of technology for immigration purposes. Chloe will talk about this a little bit more in detail. But before I'm going into maybe talking a little bit into more generally how it has been shaped in the EU, I think I want to talk a little bit about what actually is the meaning of migration, or this kind of term, which is like a complex term in per se, but also let's talk about the criminalization of migration or migrants in more specific. Oh yeah, thanks. It's complex to see it at the same time. We tried together with some colleagues to try to break it down into some three kind of patterns. Of course, there are different kind of definitions out of, but I think in basic lines is first of all, it is the use of administrative law, of the administrative list system, mainly through the administrative detention system, to, let's say, use it in the case of immigration as a sort of deterrent system, but also to organize, manage, like it has been told a lot of times, immigration. And in this case, that's why it is linked to criminalization. They're treating, and I can show you some pictures, immigrants like criminals in the same way. Here, the most important thing, I think, is to highlight that the person as such, which is judged and categorized by a legal system based on the birthplace or on the ethnicity, is basically considering the person as illegal. So this is different from what is then the second kind of use of this term criminalization, where actually criminalization in the criminal law jurisdiction is used in order to manage migration management. So migration here is not so much the person as such the target in a way, it is the act as such which is considered to be illegal. So for example, the crime for illegal immigration, border crossing, illegal border crossing, and all this kind of stuff. And we added a sort of third category because I think in our view, it is not sufficient to highlight this in this sense. I think it was important also to highlight the so-called unlegality or illegality regime that has been applied to migration policies. And it is so if you look at administrative law and it's sort of, and I will explain it a little bit later in this, let's say, more global understanding, then you see that it is actually used, especially in the migration context, with a different kind of legal philosophy underpinning, which is very problematic. Let me go quickly to some, because I don't have much time, and we can discuss obviously some of these notions a little bit more in detail if you want to. It's coming, hopefully. Yep. Just a word a little bit on immigration detention, which has been used as an administrative law tool. And basically, as you all know, or it's in the European scene, basically coming also from the human rights legal framework, we actually differentiated between three kind of ways to detention. First is the sort of pre-entry detention, mostly in transit zones, like in the airport procedures in Germany, for example, or in the zone d'attente in France, etc., etc. Then there is the classical way in the asylum procedures, and it is permitted through EU law that in some situations in the asylum procedures, detention can happen. And of course, in the return process. This is based basically on Article 5 of the European Convention of Human Rights, which basically opens up this possibility of detention, even not in a criminal charge system, so not criminal charge, but you can detain for this kind of migration management system. But it's quite limited. Which is interesting to notice here in the convention is there is a clear difference between Article 5, which is basically detention in migration management systems for administrative purposes, if you want, and Article 6, which foresees a high number, which is more for the criminal law proceedings, which have a high number of procedural guarantees that actually is not applying for the administrative part. So this is very important. So in the EU context, legal context, we basically have this implemented into two kind of directives. There's the reception, asylum reception condition directive, but also the return directive. And this has fueled into legal practice, which unfortunately is sometimes completely illegal to the European legal framework even. I can name, for example, which has been also highlighted by the European Court of Justice, case of Hungary, for example, where asylum seekers are detained in consideration, which is not foreseen by the reception condition directive. I know my time is running a little bit out. And there is something which is important to notice, that detention has been possible also in terms of for public order situations. In Italy, for example, we find a number of situations where and I think it's the same in some other countries, like in France, that a person who has been criminally charged after sentence is over from the prison, the person is generally taken into immigration detention, while other persons that might be in the same kind of administrative situation might not end up in administrative detention. So there is a clear sort of public order underpinning, which is blurred into the definition as well. Let me go quickly to this second part, which is the criminal law as a management tool. Here we find, a lot of problematics basically linked to the fact that it has been used as a tool, for example, to enhance criminally irregular entry and to criminalize this kind of mechanism overarching in Europe. There has been implementation by the facilitators package in 2002, which has been then more and more fueled into national legal legislation on criminal law being implemented. In Italy, for example, more than 2,000 people have been detained and convicted out of this sort of smuggling charges, which often end up in a sort of detention circle for them as well. So they are then criminally charged in the prison, coming out, going again into detention. And I sent you the picture of Cutro, because here, what is also interesting is you may remember this shipwreck from this year. It was very harsh. More than around 90 people died at least in this shipwreck. And the situation was that it was not search and rescue operation was going there, but it was the Guardia di Finanza going there, trying to understand whether it is a irregular entry case instead of a shipwreck case. So there's also the mindset is set in a way that actually brings it. And that brings me immediately to the last point, and I will finish with this, this code of illegal or unlegality or illegality system or a regime. Administrative law is based usually of a number of principles. And of course, this is a sort of a borderline, but it's usually based on principles like, for example, the principle of impartiality, non-discrimination, if you want, the principle of good execution, the principle of responsibility, the principle of openness and transparency. These are principles that actually gives administrative officers a sort of way to implement administrative law in a good manner. They have a lot of discretion usually. That's part of the administrative law system, because administrative law system is based on the legal action of a legal officer in the public authorities. Now, what we see in the migration management system is that this has been completely blurred down into a very problematic approach by public authorities. And I give you this example of the Libro Nero of our detention center in Turin. Last example as a case, there was a person very strikingly hit by Italians in Ventimiglia on the border. He was begging coming from sub-Saharan country, begging on an entry of a supermarket, was hit, was injured, taken to a hospital. From the hospital, instead of being sort of cured and then released in a way, was taken immediately to the detention center of Turin, where he, after some days, took his life because he was even isolated. A lot of details in this case was traumatic, of course. But it's just showing you kind of how public authorities, in a way, use their discretion, not in a way that is usually underpinning of administrative law. So putting them in sort of in an illegality system or unlegality system, which is basically underpinned of the use of the administrative law, which is different than it would be used if it would have been an Italian citizen, for example. So this is clearly based on race, and racist approach, which is also underpinning on all this kind of problematic. So I'm finished there, and I thank you very much for your attention.
Thank you. And it seems I have learned in between to use a mic. Thank you so much for this presentation. I think it's very important to see how there is a legal migration as well of the criminalization, right? I mean, like, one of the things about criminal law is that it's supposed to be in criminal codes. And what we see about migration is that there are a lot of actually criminal regulations are outside of criminal codes, and it's often because of migration. Migration is also one of the legislative area where there is the most of activity. There is a legislation around migration every year in Europe, either at European level or at national level, without ever testing actually how effective it is to create safety for all of us. I think that's a very important point. And with that framework of actually putting migrants as criminal, and not all migrants, but racialized migrants specifically as criminal, I would want to hear you a bit, Chloe, about how tech is being used in that context, and how it actually amplifies discrimination and racism, and how often, although we talk about it, when we talk about tech and digital rights, we talk about it out of context. The context is so important because it's where surveillance technologies, control technologies, policing technologies, using digital technologies are being the most developed, expanded, and useful, and create the most harm.
Thank you, Laurence. Yes, absolutely. And thank you for the invitation. I think, yes, I was commissioned to talk a little bit on two fronts, to bring two elements to the discussion. One is to see how the uptake of those technological tools is being rubber stamped in EU policies and EU law. So on one side, how EU policy is developing and how technology is being integrated to support and even, as you say, worsen the situation in migration policies, but also through practice. So non-legislative means as well play a role at EU level in this criminalization trends that we're describing. And so without necessarily having a specific legal instrument, there is an element of data collection and data processing that we can see, and that really worsen the blurring of the lines between migration and criminality. And I will take as an example in this short presentation the collaboration between two EU agencies in the field of justice and home affairs: Frontex, the border that you're all very familiar with, responsible for border management, and Europol, the EU law enforcement cooperation agency. So if we start with the first one, which is EU policies and how they develop, I wanted to give the example of the expansion, the proposed expansion, it's still on the table currently, of the Eurodac database. So now a quick background on what is Eurodac. It exists since 2000, and it's a database used to store asylum seekers' data, refugees' data, so people who have been granted the status, but also certain categories of irregular, what they call irregular migrant, but basically people apprehended crossing a border irregularly. And so by the end, to give you like a brief idea of how big the database is, and by the end of 2019, the EU stored almost 6 million people's data in this database. The database contain very sensitive information, such as biometric data, until now fingerprints mainly. There was a reform proposed in 2016 to massively expand the scope of the database. But although the political institutions, so the Council and the Parliament, found an agreement on the text, it was ready to be adopted. There has been a political deadlock on other migration files at the time to reform the common European asylum system, and therefore the reform wasn't passed. It didn't prevent the Commission from re-proposing the text years later, so along with the Migration Pact. And I think Silvia will touch upon what it is, so I will not expand further. But basically the reform of Eurodac in 2020 is based on the one from 2016 and aims to really transform this tool that was originally designed to only apply the Dublin rules into really absorbing all the objectives of the EU migration and asylum policies paradigm, let's say, which is very much focused on the criminalization of movement, right? So the database will serve the objective of combating irregular migration, which wasn't the case before. It will be an instrument of control of people's movement by trying to detect as early as possible so-called secondary movements within the EU, and it will aim to facilitate deportation, in their terms, returns. I will focus on 3 elements of the reform. There are many more, but for the sake of time. The first one is what I describe as the transformation into an identification tool. At the beginning, Eurodac was just a set of fingerprints, maybe the gender of the person, the date of registration of the data, so when it was like collected, and then the member states who collected the data, which collected the data, and that's it. We didn't need your name, your date of birth, or anything. The new reform brings all of that in. So it's name, date of birth, place of birth, country of transit, country of origin, maybe family ties, any travel document you may have, anything about the person. And that really, I guess, very symbolic, because identifying a person to that degree and collecting that much information means that you're treated as a potential suspect. We need that much information to make sure that what you're saying is true, that we can identify you in the future, and that you're also suspected of willing to move. So it's very telling that we're trying to do as much data collection and processing to judge a person's intent, background, and origin. The identification objective also serves the fact that Eurodac will be integrated into the interoperability framework. That's basically a project of the European Union to interconnect all its current databases in the field of migration and law enforcement. I'm not going to go into detail, it's a bit technical, but basically the bottom line is there is a blending of multiple objectives in this project. And really it serves the blurring of the lines between migration database on the one hand and then law enforcement database on the other, because they're just basically put together. The second element is the addition of new categories of data to the database. We already had fingerprints, which is already quite intrusive as a data collection method. Now the institutions wants to add facial images and be able to run facial recognition in the system to better detect and identify people. Like facial images are very symbolically charged in terms of criminality, like mugshots are historically, have been historically introduced in the field of crime control. So it has a very negative impact on how we treat people, because everyone will be just integrated in the database with their images. And it's a central database, and that only exists in the criminal law field, right? So we see how it intensifies the criminalization of migrants to have more and more data being collected, and in particular, sensitive biometric data. Now the text also in 2016 planned the possibility to use coercion to capture biometric data of people in case they refuse to undergo the process. That also tells you how far they want to go in making sure that everybody gets their data collected and centralized in the database. Coercion means probably mostly detention, but also the use of force is not ruled out in the text. Lastly, the final element is the detection of security threat. I think like now it's clear that it's about criminalization. There is a possibility in the reform to add a security flag to certain profile of people in the database. So if the agent who is doing a screening process at the border considered the person to be potentially a security threat, like a threat to internal security, then the person might be flagged as such, which has wider, like very long repercussion, because this information is stored for years in the database, and there is no requirement to justify why this person was flagged as a security threat. It's mostly done through the running of checks with other databases, and those databases are police database. So basically we're absorbing data from police database, Interpol database, national database, EU database in the field of crime control, and then we're replicating it into Eurodac, which is an asylum database. So here you can really see the blending of information systems, which originally have nothing to do with each other. For the sake of time, I'm going to go through the second part, which is the kind of concrete practices. Now, non-legislative means we can think of EU funds, how, for example, European funds for international security are being used to finance surveillance systems at the border and so on. But here I want to focus on the role of EU agencies and how they have been evolving in the course of time towards a more bigger operational role. And so Frontex and Europol, before, they were just merely supporting member states. They were coordinating national authorities. That was their role. But more and more, they're getting a bigger role, a more operational role. And that goes through more data processing, more data collection, and intelligence production. So producing risk analysis, assessment, and so on. And one particular cooperation or collaboration project between Frontex and Europol in the field of migration, which has received the most kind of public scrutiny, let's say, is the PEDRA program. And PEDRA stands for Processing of Personal Data for Risk Analysis. Basically, Frontex agents are doing what they call debriefing interviews when people arrive at the borders. Debriefing interviews is a euphemism for interrogation. It's basically taking people in detention who are deprived of liberty and then asking them a set of questions. The goal is to catch as much personal data as possible in those debriefing interviews. So they collect info on the journey of the person, why they left the country, why they came to Europe, with whom, how, etc., etc. You can imagine. There is no limits in terms of personal data that Frontex can do, except especially after the reform in 2019. They can also collect genetic data, DNA, fingerprints, photograph, information on political and religious beliefs, sexual orientation, and so forth and so on. The debriefing interviews also aims to collect personal data about persons suspected of being involved in cross-border crimes. That's like crossing the border illegally, or human smuggling typically, or cross-border criminal activities. And all of this information about the criminal activity is then transferred to Europol. And so here we can see that Frontex is basically acting as the boots on the ground of Europol, because they're sending all this information to the agency, and Europol is kind of tasked to produce risk analysis reports that serve then further operations on the ground. Now there has been an EDPS, so the European Data Protection Supervisor, responsible to check that everything is in line with data protection. There has been an EDPS audit, and the findings are very telling in terms of how EU agencies are circumventing every single legal protections that exist. So the first finding is that there was no legal basis for this program. So Frontex has been systematically, proactively on its own collecting data, and there is no legal ground for this, because they should be restricting their activities to migration management, and they have been doing so for investigation of crime. So this is not allowed in law. It's mass surveillance, because the transfer of data has been systematic and not on a case-by-case basis. So the EDPS has launched a second investigation, and that might lead to financial sanction or any kind of administrative sanction against Frontex. And it's also found that the way Frontex is collecting data prevents those people from exercising their fundamental rights, which means that if you have been, I would say, a target, a victim of those debriefing interviews, and you want to know what data was collected about you, you can theoretically exercise your right to access and rectification. Except the way Frontex collected the information, it's impossible for them to search through their database, which means you cannot exercise your right to access or rectification. So if something was wrong, collected that is wrong about you, then it's in the system and there is no way to change it. That's really grave in terms of fundamental rights. And so if we recap at individual level, all the data protection rights have been violated or are not able to being exercised. The agency has not respected its own mandate and its own regulations. And then if we take a broader step in terms of discrimination, what does it mean? Because all this personal information is then supposed to be fed into risk analysis, risk assessment. Basically, the fact that we are in a situation where data is being collected without any guidelines. The EDPS said that there is no reliability of the data, yet we end up with those reports, which can be very detrimental and have really implication for bigger groups. To be more concrete, and what does it mean? It means that if in those debriefing interviews, there is some information that, I don't know, a certain group coming from a certain country might be more likely to be engaged in criminal activity, then what does it mean for the next ones? And this is those kind of risk analysis reports that informs future operation on the ground. So that means obviously that there's going to be discrimination in the way the agencies, and especially Frontex, is going to carry their next operations. So it's a detrimental feedback loop where you can see how it can criminalize certain group and be discriminatory towards specific, specific groups of people coming to Europe. I think I exceeded my time, I'm sorry.
I think we will all survive. Yeah, thank you for sharing that. I think it also shows that often when we talk about criminalization of migration and this transfer, this journey, we also forget that there is another journey that has been happening before, right? It's the journey between migration and criminal law, is how actually the law that are supposed to control migrants and are framing migrants as dangerous people and as a threat actually nourish a harshening of criminal law. And that those two things cannot be disconnected, and that if we are questioning fundamentally how people on the move are treated and we understand the racial dimension, the racist dimension of it, we have to understand the racial and racist dimension of criminal law as well, and reinterrogate it fundamentally. And those technologies that you were talking about, I think is so interesting, right? Facial recognition, it's a way of doing racial profiling, and that's also where it comes from. And if we're talking about risk assessment, that all those technologies, those algorithms are practices from the police that have been amplified. And in that sense, actually technologies that are amplifiers, but are like great revealers of how those institutions have been operating for years. And so at its epitome, right, when we talk about criminalization, we end up with detention. We end up with inhuman and degrading treatment of people. And that is the highest type of punishment in criminal law in the judicial system in Europe. So people for crossing imaginary lines are actually treated the harshest way in the criminal law, right? By being detained and deprived of their freedom of movement. And perhaps Silvia, you can then talk a bit about how that is working in Europe and how that also fits in the conversation around the Migration Pact.
Thank you very much, Laurence, and thanks to the previous speakers because they already set the scene in a very detailed manner. I think my role in this panel will be more to reflect on the implications on current debates and legislative reforms, mainly in the EU Pact on Migration, but not only, and how we will see this blurring of the lines between criminal law and migration policies further being legitimized and further being part of the way in which migration and asylum will be managed in the future. So I will build upon what the other speakers have said and focus specifically on two aspects. So I already mentioned the pact and migration reforms, but also the changes that are ongoing in the way in which criminal law is used to manage migration. And there have been some very important proposals just yesterday announced by the Commission. So I will briefly touch upon them just to start understanding and analyzing what could be the implications for the future. So to be very, very brief, because it's impossible to cover the whole pact in a few minutes, I will start by looking at the element of detention. So maybe just an introduction for those of you that are less familiar with the Migration Pact. It is a set of legislative proposals and policy measures that intend to shape the way in which the common European asylum and migration system will work in the future, which include not only the processing of asylum applications, but also, and in an increasingly strong manner, also return and deportation of migrants. And often, as Alyna has mentioned in her presentation in the previous panel, this means, let's say, a binary choice between who is, let's say, the good asylum seeker, the good migrant, and who has to be returned. So in many of the proposals of this pact, we see not only this binary sort of reflections, but also the use of detention, as Ulrich has mentioned, as a way to contain migration and to prevent and punish the movement of people. So especially the grounds of national security and public order, which are extremely broad grounds, are used to sort of leave member states with that discretion to decide who can be detained, whose freedom of movement can be restricted. I included just a couple of examples in this slide. First of all, from the recast of the Return Directive, which is probably the most obvious file where we can find these examples. But I also want to highlight the Asylum Procedure Regulation, which is one of the key legislative proposals in the Pact, and which basically should regulate the way in which people apply for asylum and the way the procedures that are used at national level to grant them protection. And it actually has been drafted and conceived in a way which allows for expanded use of procedures that provide with way less safeguards. So you probably already heard about these accelerated border procedures that have been introduced, not only for asylum, but also for return. So we see the return element also entering more directly and prominently the domain of asylum procedures. And these procedures are also very likely to entail detention, but detention won't probably be called as such, but it is almost impossible to make sure that people will remain at disposal of the authorities without measures that will actually restrict their freedom of movement. And we can think of the example of the Greek hotspots to understand how this might play out when this is implemented. So border procedures are particularly concerning and again are linked to these questions about national security, public order, because this will be one of the grounds for which applicants might be sent directly to this kind of procedures. And this means not only during their potential asylum application, but also in order to return them to a fair country. And I also mentioned the inclusion of children, because I think it's quite a dichotomy to say that children can be a threat to national security or public order. And unfortunately, this is, at least to some extent, included also in the proposals and in the current negotiations. And I think we've heard behind closed doors, a lot of people dismissing the grounds for detention for children by saying, okay, but if they're criminals, then it's fine, which is, let's say, I won't even start to say how problematic that is. Moving to another dimension. Okay, is, oops, too fast. Sorry. So the dimension of narratives of migration as a threat. This is maybe a more general point, but I think it also works very well with what the previous speakers have said, because we don't only see measures that can be directly linked to criminalization, but also measures that more indirectly frame migration as a threat, as a criminal issue, and that then have, let's say, a consequence in the public perception, but then also in the way that migration is managed on the grounds. And for this, I've mentioned the screening regulation proposal. So this regulation is considered to be less contentious because, let's say, it only creates a procedure to identify people at the border, but such procedure is very likely to entail also the privation of liberty, and in particular, it will be applied not only at the borders, but also on the territory of the member states. And this proposal is particularly concerning because it shows the extent of the policing that could be implemented. And this is also very much connected with Chloe's presentation, because under the screening, there will be data collection that will then be fed into the various databases that we just heard of. And the fact that the screening could be applied in the territory also entails a very broad risk of racial profiling, because basically, how do you determine that a person has entered irregularly, if not by their appearance? So this proposal, we find it extremely controversial. We also have a joint statement that I put in the slide. The link is available together with the QR codes that have been prepared for this legal seminar. So please do have a look to see the whole list of concerns. And then I also mentioned the Schengen Borders Code, because in the Schengen Borders Code revision, we also see how migration is more directly mentioned as a threat that can also be the basis, for example, for the reintroduction of border controls with all of the consequences that we see in several areas, as for example, the Italian-French border that has been mentioned in the previous presentation. And then, also mindful of the time, I'll move to the final part of the presentation, which looks at the more traditional, let's say, criminalization. And if I manage to move. Yeah, so this has also been mentioned by Ulrich, this famous facilitators package, which is a set of legislation which was introduced already in 2002, and that was the legal basis at the EU level that led to criminalizing not only solidarity and NGOs, but also migrants themselves. And it has been for very long a framework which has led to many derogations and exceptions in the way that the criminalization of solidarity was conceived. I will be very brief because I would like to leave some time for Q&A, but basically just yesterday, some of you might have seen it, the European Commission has organized this very big high-level conference on countering migrant smuggling, to which, of course, only member states and third country representatives were invited. And this whole framing was to denounce basically the dangers and the criminal dimension of smuggling. And during this conference, there was also a new proposal to revise the norms that lay down the rules to actually criminalize the facilitation of unauthorized entry, transit, and stay in the European Union. And why is this important? Because, and also civil society has denounced it for a long time, these rules have been used as the basis to criminalize civil society organizations, to criminalize people helping migrants on grounds that they were facilitating and helping legal migration. The new proposals by the Commission, and we haven't had yet the time to analyze them in detail, at least acknowledge that this has been an issue in the past few years. So there has been a small step forward in the sense that they try to link a bit more closely the criminalization, for example, with the element of exploitation and financial gain that could be part of smuggling. However, and I mentioned the conference and the smuggling framing, this might still be problematic because we see that this is not just done in a way that means to facilitate the regular movement of people, but is still under a very strong policing framing. And we see it in the second of this proposal, which is actually a regulation that will reinforce the role of Europol and also cooperation between agencies to fight migrant smuggling and trafficking. And if you've listened to Chloe's presentation, you probably have an idea of what this might mean in practice. More data sharing between agencies, but also data sharing with third countries, and also more capacity on the grounds to what is defined as tackling criminal smugglers, but actually might entail actual prevention and further punishment of people's movement. We will certainly work on it further as PICUM. We will produce some analysis, but I felt it was important to already point you to these developments because I think it will be very important also to tackle them and to analyze them together in the coming weeks and months.
Thank you. Then I'll open the floor to Q&A. Sorry, can we prioritize Black women there? Yeah, thank you.
Merci pour la parole. Je suis désolée, je veux parler en français. Parce que
to apologize because I'll be speaking French. Belgium did not give me the opportunity to learn other languages, so I would like to ask you to let me speak French. I'm an undocumented person and I would like to thank PICUM. Thank you for your organization. Thank you for everything you are doing to help us, to enable us to get out of this terrible situation. Now, you were talking about detention and return, and I would like to tell you what is happening here in Belgium with the ECAM coach. For the moment, we are in what we call psychological detention because the Foreign Office organized voluntary returns, and undocumented people are invited to receive information about voluntary return. And you also need to think about the attack that happened here in Brussels. Apparently, undocumented people are worse than terrorists. And so my question is always the same. Who have we killed? Did undocumented migrants kill anyone? And yes, I know that we had these attacks and that guy who killed 2 Swedish people. But of course, we cannot treat everyone on the basis of this attack. Then I would like to tell you about what is happening in the framework of this voluntary return. And can we really use the term voluntary? Because Mrs. Nicole de Moore expressed her views in the media, and she said it was possible to speed up forced return for people who finalized the coaching procedure and who did not cooperate. But we're talking about voluntary return, so I should have a choice to go back to my country or not. But if this return procedure did not happen, and if I did not agree, then it becomes a forced return. So this is really a strange psychology, and I would like to know what is the contribution that PICUM can make at the level of this voluntary return, because we can consider that we are in psychological detention. It is detention because all of our data are known, and we do not know when we will receive the visit of the police forces, and we do not know when we will be invited to this voluntary return. And I would like to know what PICUM is doing about this psychological detention for undocumented migrants in Belgium in relation to this voluntary return. Thank you.
Thank you very much. I apologize if I answer in English. I hope it's perfect. Thank you very much for being here and for bringing this testimony. I think it's also very important to hear from people that live this every day. From PICUM's perspective, I can tell you that we also work on the dimension of returns, or rather, let's say deportations, to give you what we prefer as the framing. On voluntary returns, I think that we often confuse the concept of voluntary returns, because it is often promoted as something that should help the person through a process to bring them to voluntarily go back to a country where they might not have personal links, where they might not have a job, where they might not have perspectives. And this is often used in the narrative of the states as a positive solution that is opposed to the violence of the forced returns. But as you're saying in your testimony, this doesn't mean that that returns, voluntary or not, are the positive and the only solution for people who are undocumented. And at PICUM, the work that we try to do is to look at the other solutions that can be found in the individual case of people. So in the circumstances specific to Belgium, it is mainly through the work of our members that have the possibility to work more on the national territory. But I can tell you what we do at the European level, which is to always try to advocate for case resolution in a manner that really entails finding regularization options. So advocating for access to residence permits, be them on grounds of human rights, on grounds of health, children's rights, family reasons, but permits that also allow people to live a decent life in the country where they are. And this is also very much linked to the question of what are the labor pathways that people can access, or pathways for educations, but always trying to really explain that the solution is not always return, and that undocumented people often have very well established lives and contribute to societies, and this should be recognized also by states.
Thank you. Just also to recognize numerous questions in the chat. Okay, great.
Yeah, well, as you can see from the 99 plus notifications, there is a very active chat, a lot of interesting comments, but I'm picking one very specific question that I think it can be easily addressed. Maybe it's for Chloe. Elena Ham from the EPC, she was asking if, do we have any data on the extent to which authorities were or are collecting such extensive data under PEDRA to have a sense of the scale of the data collection?
Good question. Do I have the data? I think I had the data. Did I? I think it's. Can I search and go back to you? I know that data is available because the program has been running since 2016, and I know that there has been a report, not even 2015, under the previous director of Europol, and I know there has been a statistic. I don't remember currently, to be frank.
Any other questions? In the back. And I think that will leave you time to find the information. That should be our last question.
Okay. My name is Roxanne from Fair Work Belgium, and I just wanted to maybe pick in on the remark which was said. It's not really a question, but maybe more like an open question. Because now we talked a lot about, I think, how criminal law is used and as an influence on migration law and to enforce migration, but also how it works the other way. Because, for example, after I don't know who followed it, the terrorist attacks in Belgium some weeks ago, it turned out to be quite a scandal because the Belgian justice made a mistake. The direction of Belgian politics were to build a new detention center, which is also for the criminal system quite problematic because it's already underfunded and it's also not a solution. So I just wonder if anyone is really looking into how the influence also of migration law on criminal law works and the consequences of this.
On that point, I think a lot of people are working on it. A lot of people that have an abolitionist framework around prison and borders have concentrated their efforts into looking at this conflation and trying actually to understand it under one hat and understanding what the undercurrent there are. So what is the narrative around producing safety that they are actually held under, so that are holding them, right? And it's the question of, okay, closing things is creating safety. So creating imaginary lines or creating places to lock people in, that is creating safety. We've been seeing again and again and again that it's not true. And I think it's one of the only policies where actually failing means more money. So I think that's a very interesting thing. And that's again the question of evaluation and what are the criteria of evaluation there. And so talking about migration without actually interrogating fundamentally what criminal law is and what it does and who it actually targets, I think leads to failing strategy. In the same way as like talking about technologies without talking about the context leads to failing strategy. Talking about migration without talking about criminal law leads to failing strategy. And talking about criminal law without talking about migration leads to failing strategy. And talking about all of that without talking about anti-racism and having anti-racist practices is a failing strategy. And I think we are right now seeing the consequences of this accumulation of failing strategies in Europe with the rise of far-right people accessing power and of far-right ideas and movements in the streets and beyond. You want to add something to that? Yeah.
Thank you also for this last comment. I think it's very important to retake sometimes the discussions about criminal law and the use of migration law in these patterns of criminal law. In the discussions of criminal law usually has, how actually a certain criminal law provision has a certain effect on the objective it has been created for. So it's very important, I think, to look at those kind of effects in a certain way, and come back. If you would analyze, for example, what kind of effects the criminal law perspectives on migration law has in terms of what policymakers often claims for what the objective is and what it is really achieving, actually it is not achieving at all these kind of objectives for clear sake. And it's very clearly, to put it frankly, in the words of François Crépeau, who was saying these kind of laws has been done by non-migrants for non-migrants, basically, and not really taking into consideration the situations of non-migrants, of migrants who are basically attacked by this kind of law provisions. So I think it's very important to take this kind of discourse in our sort of discussions as well, because I really feel that we turning once, and we mentioned here, one criminal law sort of enhancement after another in migration settings, which in the end is not serving any kind of objective. It is at least declared to be the objective of this kind of laws. So I think it's very important to take this into consideration, so taking also responsibility of policymakers on their kind of claims they have.
To answer the question about the figure, to give like a brief overview, I found one number. So Frontex would have shared with Europol the personal data of 11,254 people between 2016 and 2021. So now that was, as I said, just the first version of the program that has been expanded. We can assume that it's way more people, and also some of the debriefing interviews don't necessarily land in Europol's hands. So you can like imagine that it has affected many more people than just this number, and it's ended just in 2021. So the program has been continuing in the meantime. That can give an overview of how much. And also recently, I think in October, it was revealed that among those people who were referred to Europol for suspicion of criminal activity, in six instances, it was NGO staff.
Great, thank you for those very factual closing words. Yeah, I appreciate it, you know. So yeah, thank you all for contributing to that discussion. I hope in the next panel we'll have more people that are both affected and actually have the knowledge. It's always great to have that perspective. It gives another tone and also another type of expertise. And yeah, thank you all.
Thank you, Laurence, and thank you for Chloe, Silvia, and Ulrich for the great panel. We're moving into the same topic, but diving into more specific case studies. So I'd like to invite Laure Boudrier to come, who will moderate the next session together with our three speakers. But briefly, to introduce Laure as they come and sit. She is a lawyer based in Brussels, where she currently is working as a researcher and lecturer for the Université Libre de Bruxelles in criminology. She also acts as a volunteer prison monitor in a large pretrial detention prison in Brussels, and since 2020 heads up the appeals committee that adjudicates on complaints from detained people against the prison administration. So welcome. We have a bit less time, but we'll try and be as flexible as we can so that you can all really, still share your contribution. But maybe just still to highlight that we have interpreters. So it's also for Laure to keep the time. I don't know how long the interpreters can really stay. So we can extend a bit, but just keep in mind that we have interpreters online following us, and we'll have a final reflection as well after this panel. So over to you.
Thank you. So I'd like to start by thanking PICUM and Equinox for organizing this event and inviting me as well to host this panel. And thank you all for being here today. So I'm joining you, as Louise said, with experience, some experience of the criminal justice system, both as in terms of EU advocacy, as a prison monitor as well, in a prison here in Brussels, and also now from more of an academic perspective in criminology. So just down the road where I now do research and teach as well at the ULB. And in each of these different capacities, the intersect and dynamics between migration control and criminal law and policy have very clearly emerged and very much called to be explored and understood together. They very much merge in a framing around security and danger. And I think that Sandrine's words earlier, that undocumented people are now perceived as a greater threat than terrorists, is incredibly powerful. And in the previous panel, this intersection was focused on the EU framework, particularly pertinent considering the launch yesterday by the European Commission of this global alliance to counter migrant smuggling that Silvia mentioned earlier, with obviously new legislative proposals aimed at increasing punishment, reinforcing tools of oppression for member states, and of course, further muscling up the EU agencies of Frontex and Europol, which makes it particularly timely for us to come together and question that assumption that more punishment and oppression is the solution, or indeed at all needed. And part of that reflection requires us to be aware and to visibilize the harm, the very multiple and deep harms that this approach causes. For instance, psychological detention, as Sandrine mentioned again. So we can challenge this logic and make a space for something else to emerge. So a warm welcome to our panelists who will help shed lights on the harms of border and policing by sharing with us their work, their experiences, their perspectives through case studies in only 8 minutes each. So good luck. So we have time for interventions from the floor. So first we will hear from Sarah Trainer. Sarah is engaged in social work in Sicily, accompanying people who are criminalized when they arrived in Italy, as well as those who are criminalized for helping people arriving. Sarah is a member of the Alarm Phone Network, a hotline to support rescue operations, and of the working group From Sea to Prisons, which she'll tell us more about, as well as of the Captain Support Network. And then I'll just introduce everyone and then turn over to you. Next, we will turn to Selma Bek Khalifa, who is a Brussels-based lawyer specializing in migration law. She's well known for representing many families who've been harmed precisely by such forms of state violence, and particularly police violence, and has supported and participated in many mobilizations by migrants in Brussels. And then we will hear from Lamprini, and I'm sorry for the pronunciation, Gito Costa, who focuses on issues related to data protection and privacy, cybersecurity, health, and anti-discrimination, and is currently director on AI and human rights at Homo Digitalis. Thank you all for being here. So Sarah, turning to you, can you start by telling us about the criminalization of migration in Italy and share with us your reflections on how this policy may be challenged and resisted? Thank you.
Thank you very much, Laura, and thank you, everybody. In this intervention, I will be focusing specifically on the criminalization of people who are arrested upon arrival in Italy, on the criminalization of on the accusation of facilitating irregular entry. So essentially, people who are accused of conducting or driving the boats that arrive into Italy, and people who are accused of supporting that, or so being the alleged crew. However, there are people who are criminalized for facilitation, also crossing land borders and crossing sea borders into other countries in the EU. Just to give you an idea of the extent of the phenomenon in Italy, our research has estimated that more than 2,800 people have been arrested in Italy for boat driving or being part of the crew since 2013. Civil Access in 2023 showed that there are currently 1,100 people, about 1,100 people detained in Italian prisons with this accusation. And just to give you an idea, also, for example, in Greece, the number is almost double. And people who are criminalized upon arrival in Italy have different stories. They come through different routes as well. People departing through, taking the sea routes, might be leaving from Algeria, Tunisia, Libya, Egypt, or even Turkey. And essentially, the only thing that people who are criminalized have in common is this accusation. This is the reason why we would like to start by problematizing and really frame the discussion by problematizing the fact that there is a law, the existence itself of a law that criminalizes and provides for criminal punishment for people simply for having helped themselves and others cross a border. The protected legal good in the crime of facilitation of irregular entry is the border. And this is something that is recognized in law. But what we would like to do is look at this law itself rather than reproducing legal reasoning based on evaluations of innocence or guilt or moral hierarchies of whether a person is more or less deserving of criminal punishment. And it is with this perspective that we went into this research, and we came out with a clear step-by-step overview of the way that people are criminalized upon arrival in Italy, which can be accessed in the report From Sea to Prison, available online. Essentially, I'll go through the main steps very quickly. There's an investigation opened at every disembarkation of boats arriving into Italy, but also other EU countries, that often leads to the arrest of at least one, but also more people with this accusation. People are then brought directly into police station and then into prison, often without access to appropriate interpretation and often without having a clear understanding of what is happening. Having been arrested without often knowledge of Italian in this case, and without a social network on the territory, people who are criminalized in these situations are assigned state-appointed lawyers who sometimes do not have capacity or also the possibility to defend in detail the person who's being accused. The accusations are often based on witness testimonies that are extracted with more or less pressures and incentives towards people who have just disembarked. The time that people have to spend in prison under these conditions then becomes state-appointed lawyers are often forced into, or lawyers in general are kind of pressed into opting for plea deals by the system, which often entails then not going into the merit of the case or examining the evidence. And then upon release, and there are other obstacles that people face at being foreign citizens without the possibility of accessing and understanding through the language, the penal, like the carceral system in Italy, which we can go into in the Q&A. But essentially upon release from prison, then people are faced with more detention, essentially, because people, as Ulrich was mentioning before, people who have been subjected to criminal sentencing then are also subject to administrative detention. There are increased legal structures and political incentives for administrative detention after incarceration. This is based on a number of points, including assessments of social dangerousness, social danger, and threats to public order, which we can go farther into. But essentially what it's created in these situations is a continuum of detention by which the person is subjected to different forms in a complete conflation between these different systems. It creates chaos and unpredictability and often ends in deportation. So the criminalization is based on Article 12 of the Italian Immigration Act, which was introduced in 1998. And it was followed 4 years later by the introduction of the facilitators package. So it's precedent. It is now, with the Cutro shipwreck, been amended to increase penalties and to expand jurisdiction. And this is being mirrored by this new proposal, which is for a second time in history copying the Italian criminalizing tendencies. And the consequences of this, in terms of also the way this is implemented in national laws in other countries, are extreme. And I can share more information and data on this in Q&A. But essentially, I just wanted to make one more point about this, that when we talk about people who have driven the boats, through collective discussion, we've come to the conclusion that we prefer to refer to these people as captains, because this is the way that people that we've talked to who have been subjected to these criminalization processes often choose to refer to themselves, even though we do recognize that a lot of people who are criminalized here are incarcerated and sentenced under our system while actually not having driven and not recognizing this definition. So just to go a moment into our solidarity responses that have been set up in the last years to respond to this, just wanted to touch on the Captain Support Network, which is a transnational network that's been developed to advocate against the criminalization of people on the move, to conduct research and develop useful tools and information material for criminalization, and to follow cases of boat drivers, offering social legal support to people who are detained, and also after release, trial monitoring, campaigning efforts in different countries, in different regions, and you can find them. I've linked the resources and the PowerPoints that will be shared. And also channeling resources, both economic and social, to people who are being subjected to criminalization. And then I just wanted to bring a more local example in Italy. Based in Palermo, it's a siege prison project. It's a working group that is providing social legal support to criminalized people from outside, and giving support to technical support to operators, legal operators or social operators that are working in and around this criminal justice system. I don't know if this is all the time I have. I probably exceeded it. Yeah, so I guess we were also discussing how it's important to combine different practices when it comes to responding to criminalization, because of course it's necessary when it comes to the individual defense of a criminalized person to recur to policy frameworks and legal terms, and these binaries of innocence and guilt, such as, you know, a defense that has been successful in Italy has been the state of necessity. So a legal defense on the basis of the fact that the person was forced, for example, to drive the boat. But this is obviously not enough to really actually respond politically to when we're talking about the broad phenomenon. It is not enough to respond to this. And this is why I think it's important when we do have a discussion about this to make it primarily a political discussion that puts into question the existence of this whole infrastructure in a radical intersectional way that is critical both of the bordering and carceral aspects of this phenomenon, because it does affect, it affects the people, it affects thousands of people, but it affects our society as a whole.
Thank you very much. Thank you, Sarah. Yes, I think in criminal justice work, there's been a reflection on what's called the innocence trap, where we're stuck in that guilt versus innocence binary, which in fact just comes to reinforce the logic of the criminal justice system of punishment and oppression, and binaries equally. That's good learning in terms of looking at migration control and what Silvia was describing early, all these binaries that exist in the migration pact and justify detention of people who don't meet the criteria of whatever criteria said. And going back as well to your point that all of this is actually just a legal construct, a social construct. The law it's the law that creates the crime. It's the law that creates criminality. It's very much a policy choice that's been made, that's being increasingly made by governments in Europe, but that can also be reversed and changed. And it's also good to highlight how the dynamic between national law and policy and EU law policy, as you've done, that really come to reinforce each other in this sort of, to pick up your term of continuum, a continuum of detention when people are arriving at the EU external borders. And now turning to Selma, obviously control and restriction of movement doesn't stop at the EU external border on arrival. And we see police in this continuum in Belgium very much directly implementing migration control, therefore within EU borders, and putting people at risk, at harm in very real ways of violence, and including in particular the shooting of a 2-year-old girl of Mauda in 2018. Selma, you represented her parents. Could you tell us more about this case and also your work and perspectives? Thank you.
Thank you. Then I would like to give very concrete examples of what that means, criminalization. Mauda was a 2-year-old girl, and she was shot in the head by a police officer. How is that possible? Then a police officer take his gun and shoot a girl of 2 years old in the head. How it comes? It comes from an operation, a police operation called Medusa. Medusa, if you know, it's the Gorgona from the mythology, the Greek mythology, who change everyone who see her in a stone. She petrifies the people with fear. And the police decided to give that name for the operation to search for migrants. We want to petrify you with fear. And in that terms, it becomes logic that we kill your children. How to make you fear enough to make you not come in your country, in our country. We want you to be so afraid that you will not come. With that case, in the beginning, they tried to hide it. They killed that girl. She was in a van with 30 other migrants. And the same night, they give order to leave the country to everyone. That means that they want to hide it. Even the parents, they received the order to leave the country. It's because of the civil society who decide to help them and to decide to denounce it to the media, that we could have a file. And even if we was fighting a lot, we couldn't have a real file against Belgium state. It was a file against Belgian state, and the file against the police officer who killed. He took 10 months of prison with suspension. Don't be afraid, a policeman in Belgium doesn't go in really in jail. He didn't stay 1 day in jail. And the state continue with the Medusa operation. They even don't decide to stop with that Medusa operation, even if they could see the consequence of that operation. If the order given to the police is you have to stop all of them, you have to make them afraid, you have to terrify them. Of course, it gives the license to kill for those policemen. For people who don't make any crime, there was any crime. They were not dangerous. They had no weapons. There was no reason to shoot those people. There were only migrants. And I think that it's a good example to see how far the European anti-migration law can go. The second example I wanted to give you is the solidarity case. It's a most optimistic case. Belgium prosecutor decided to prosecute 11 people for human trafficking, as she said in Italy. In those 11 people suspected from human trafficking was 7 migrants from Egypt and Sudan, and 4 people who host them at home, because with the problem of the hosting, a lot of people were in the street. Some people accept to host. It was a platform from citizens in Belgium to host migrants. And 4 of them were prosecuted for human trafficking. To show you how much the justice is racist, they were 11. 7 were undocumented migrants. 4 had papers. In the 4 who had papers, 2 were, I will say, white Belgian women. 1 was a Belgian woman, but with a migration background. She was originally from Morocco. And 1 was a Tunisian guy with the paper, but Tunisian passport. They were arrested all the same day, same hour at 5 o'clock in the morning by policemen with cagoule, like that, and very big operation. People who did nothing against hosted people. The 2 white women were released the same day. The Belgium with Moroccan origin stayed 2.5 months in prison. The Tunisian stayed 8 months in prison, and the migrants stayed 1 year in prison. In pre-trial detention. In the file, after the 4 hosters were acquitted, and the 7 migrants were guilty. Guilty for what? They invent a conception. Normally, for human trafficking, there is one, you help someone to cross a border or something like that, but there is one condition, is that you win money with that. Nobody won nothing in that fight. But they invent something to say, yes, but one migrant, if he help the trafficker he didn't receive money, but he helped because he hoped to be in the next trip for free. It's like receiving money because normally the trip cost money. And if with his help, he could save that money, it's like if he's receiving money, it's very complicated, huh? But then he is guilty. That is the second thing, that in the same times you can see that a policeman who killed a little girl didn't receive any day of jail, and some poor people who tried to cross to go to England receive more than 1 year of jail for only because of they tried to join England. And I would like, if I have time, to finish by a third example of criminalization of legal people. Junior was a young boy from Congo. He received a visa to come to study in Belgium. Everything is okay. He has his university, his inscription, he received his visa. He came here, and the police officer in the airport of Zaventem decides on his completely without reason to ask him more questions. And he began to ask him questions to know where you will go to live, which kind of transport you have to take from your aunt's house until the university. He couldn't answer. It was his first time in Belgium. What do you want to study? He began to question him on he asked him question. The boy has a baccalaureate in science. He asked him question about the tableau de Mendeleev in the border, in the airport. The boy couldn't answer. He couldn't understand why they put him in detention center. We fight in that file to say that, but you cannot put legal people in detention center. In the tribunal, the lawyer of the Belgium state said that sentence: a visa doesn't give you the right to enter in the country. But what can you do with a visa except to enter in the country? Give me one other purpose of a visa. Then they defend, and we won on the first instance, but the Belgian state is in appeal because they defend that they have the right to detain someone with a legal visa. They didn't say that it's a false one, or they say it's a real one. We give it, but even if we give it, when you arrive, we can take it back. That was my third example of criminalization and craziness of our migration politics.
Thank you very much, Selma. I think your testimony critically adds to the migration and criminal intersect the racial dimension, the component, where we see that, is it all right for the sound?
that criminals have, migrants have long been constructed as migrants, but also imagined specifically on racial terms, where the criminal is constructed as someone other, someone foreign, someone strange, and criminalization, in fact, is integral to that part of othering a person. And then once that's done, through these widely construed social representations, it's then used in turn, once it's acquired by the general, in general thinking that migration on racial terms represents a danger, then it's used to justify violent policing at the borders and very restrictive migration policies. Because there's that imagined risk of a danger that lies beyond the borders. Something that's a very important testimony to add this further dimension to the discussion. And then also that even when you have the shooting of a 2-year-old baby, you still maintain this policy. You don't change it at a state level. You don't question the policy. On the contrary, you're actually increasing the tools to policing. And now, turning to Lamprini, we see all sorts in here of new digital surveillance tools that are being deployed against people arriving in the EU. And we heard earlier in the earlier panel from Chloe and Laurence on how they are both amplifiers, but also revealers. I thought that was very well put from Laurence on the intersect between migration and criminal law. So can you share examples of such technologies and their uses? Thank you.
No, that's fine for you. Yeah, no, great. Thank you. So, hello from me as well. I'm Lamprini from Homo Digitalis, and I would like to thank PICUM for the invitation. Thank you very much for hosting us here today, and to Laure for being the moderator of our panel. In the next 8 minutes, I will be I will not keep you longer, I promise. But what I would like to do is indeed, as actually the title says, I would like to show you how actually infringement and breaches of data protection law may actually blur the lines even more when it comes to migration law and to criminal law. I will use 3 very specific cases that unfortunately have been ongoing in Greece for the last 2 to 3 years. I will be very quick with the information. So it's okay. I usually have a loud voice, but I'm a little bit sick. Sorry. Yeah, I will be slow as well. Yeah, I talk too fast. Sorry. But on this note, yes, I would like to conclude then by saying what are the risks for people, and especially for people who feel more vulnerable than us in these kind of situations that we've heard today. But also, what is the current state of play in Greece when it comes to new technologies that may actually, you may see it everywhere currently, but also what the difficulties that we face also as a civil society when it comes to defend these things. And with this, I will conclude. So the first case, can I use this one for the, brilliant. The first case, actually, it's about biometric police gadgets. So I'm talking about smart policing. Imagine that this case started back in 2019. Okay, so the police said, I would like some kind of cameras to have on me, biometric data, which means facial recognition primarily, because this is what they wanted to do to identify people, especially people from third countries. So we are talking about non-Greek citizens. What happened is that Homo Digitalis, the organization I work for, requested access to this information. We got some information, but it was not very clear, because just to highlight, for situations like this, data protection wide, we need to have an assessment of the impact these technologies should have on people. We didn't get clear answers. Long story short, since March, as you see there, to date, November, almost December 2023, we filed a complaint, we asked for information, we actually complained to the Data Protection Authority, because again, it's about data protection, not criminal, no migration law. And there is a kind of a decision pending. Please hold to that, because we did not get the information yet. We do know that they got the contract. We know that they got the devices, and that's as far as it goes. So we are trying to see through the Data Protection Authority what are the other issues. So point one, not so transparent, not so easy to get the information, but at least we try. Let's see. Second case, which is the Centaurus and the Hyperion. This is extremely, extremely important because, as you see, it talks about closed control access centers. So those of you who have worked in Greek islands, I know you may actually empathize with this, because as you see, we are talking about 9.4 million euros of a project. This is not peanuts, this is serious. And what they do, they have, so part of the functions, I will not go into the details, but part of the functions are actually to spot irregular behavior in groups, how they gather. They deploy drones so that we can have, you know, what happened, what incidents we have there. But these are two overlapping, not overlapping, complementary projects and systems, let's say. So most of the information, again, there, confidential. What we've done, complain to the authority. We're trying to get information, but this is not the end of the story. This actually system is now going to be complemented by another one, which is not on the slides, and it's called Reaction, talking about artificial intelligence in Europe as well. Please be aware, because Reaction combines everything. It's a holistic, interoperable pilot system in Greece for the time being, funded by the European Union, to actually see whether we can detect people, faces, movements, access to everything. Again, what is the problem? We do not have all the information. We don't know what kind of safeguards they have in place to make sure that the data protection law at least is respected, especially in these situations. The third case, which is a showcase of how, and this is very, it's a bit spooky in what sense? Apologies for this. So social media monitoring app, we put this also here. We also filed a complaint about that, but bottom line is, imagine what this kind of tool can do. The reason we have this here is to give you an idea of how easy it is to actually impersonate an account on social media and, you know, put something on your phone, not everyone's phone, people who are migrants, who are coming, here we are talking about the Coast Guard of Greece. So where would they apply this? To me, or when I go swimming? I don't think so. So they are actually doing this when they are patrolling. So what they've done, they can hack, they can get information, everything on people's Facebook. People, I'm talking about people who are on the boat, try to move from one country to another and save their lives. So list of contacts, everything, information. They can just have access, collect, create their own database. So based on this, they can profile and they can see their behavior. Again, is it about criminalizing? Is it about profiling? Is it about making someone a suspect or not? Unfortunately, and this, with this, I would like to actually, before I conclude, for a similar case, Privacy International had filed a complaint before, which is another NGO on digital rights, and they have won it. So actually what's happened, the system stopped. We hope that we will have something like a positive result, but just to conclude, knowing that we are very short on time, just to tell you that in Greece, we know that there is a lot of investment on surveillance, border controls, and all these kind of detention places that they have in all sorts of places now and all islands. We know that this border management and border control is part of the digital Bible of digital transformation. And no, it is actually immense. This is not just one thing. It is a 5-10 years thing. So there is a strategy behind it, and migration and border management is part of it. The difficulties there, and with this I would like to close, is that even if what we face is that we have new technologies and we try to understand what would be the impact on people. Imagine, and I think Chloe mentioned before, and she was not the only one who mentioned, like, what if, and actually we know that some of these systems will be interoperable and interconnected at EU level, but also at Greek level, at national level. What if we do, because this is where it goes, connect all these databases? Where are we heading? How is this data collected? How are these databases being actually legitimized? And for all these, we have very, very strong concerns. The progress, unfortunately, in Greece in these kind of complaints, as you see, it's extremely long. We have a data protection authority that is doing their best, but they're completely understaffed, and we have all these issues. And my question is, and unfortunately with this I close this intervention, there are people who are suffering. We are trying to protect, we are trying to defend. There are more things coming, new technologies, and there is slow progress. So where are we at and what we can do more? And I think by raising awareness and discussing this with you and exchanging similar experiences, we can become a bit stronger, and we can defend even better our rights, especially in Greece. So thank you.
Thank you very much, Lampini. I think the examples that you shared really reveal that at the heart of the development of these technologies lies always this logic, this idea that crossing, that movement, that crossing borders is inherently dangerous. And that the EU is fully on board financing these projects, these new technologies like RoBorder, these unmanned drones that are being funded. I think it's 2 billion euros under the EU Horizon project, where police forces are being funded to gang up basically and create this further border surveillance system. And it really ultimately to me sounds like even though these technologies are new, pretty shiny for the police authorities and for us lead to unknown consequences, we're still in the same old logic of segregation and exclusion. And that's really the logic that needs to be interrogated if we want this system to change. So thank you very much. And I'll now open the floor to the floor for interventions, thoughts, comments, perspectives, questions, obviously.
Thank you. Yeah. Bonsoir tout le monde, merci. So thank you to PICUM and to Equinox for the invitation and for the panel, and thank you to all the panelists and to all the people here. So my name is Esther. I am a migration and refugee lawyer in Spain, and also anti-Black racism activist and advocate. And so basically it's a comment, but also a response to the question of what else can we do, and it's something that we've been thinking about. So basically we can see that there is a political will and the intention to block, to deter any migration from the south to the north. And it doesn't only happen in the European context, but it also happens, we can see it in the North America context. And all those systems of criminalize and blocking migration, whether it's more digitalization of borders. For example, in Spain, we have the smart borders, which is Ceuta and Melilla, top technology, whether it's collecting more data to control movement or scrapping the asylum system with the EU Pact on Migration. And by the way, the asylum system was never meant for people of the South, because in 1951, we were colonized. So we also have to keep that in mind. All those different systems of blocking migration from the South to the North are in a wider system of structural racism, basically. So I think we need to keep that in mind. This is the environment and the world we are moving into when we're trying to advocate or defend from a legal perspective, from a activism perspective, or at different levels. So in my work, and also because I'm part of a broader network of organization of people of African descent. We try to connect the reparation movement for people of African descent and try to think how, because reparation is about us, it's not about giving back cultural artifacts to the museum, from the museums. It's about implementing policies at global level. It's about challenging structural racism. It's about challenging systemic racism and understanding that systemic racism is a reflection of the whole structure. So basically what we're doing now, to trying to do something, since we see the more there is criminalization, the more there is also impunity. As you might know about the Tarajal case in Spain or the Melilla case. So the level of violence increased, but also the level of impunity of public officials, whether the Ministry of Interior, law enforcement, or all the instances of law enforcement and administration, they are totally impune. There is no way, even though if you put a complaint, you go to the UN, you go to the EU, there is, the more violence there is, the more impunity you are faced with. So what we're trying to do is to have conversation with the African diaspora here in Europe, but also conversation with African civil society on the continent, and how we can think about policies within the framework of reparation. How do we affect migration? For example, a policy of reparation would be, for example, to give documents to all undocumented migrants in Europe that are from African descent, or a policy in the context of the reparation movement would be, for example, having policy controls of how law enforcement affect people of African descent at borders. So this is something that we're trying to do, because we see that everything that I've been working in migration since 2004 in different contexts. And every time I see that things are getting more hostile, that the European Union is kind of coordinated in this hostility, that there is no, how do you say in English? Il n'y a pas de répression in terms of political officials to say, no, we don't want migrants, we don't want Black people, we don't want Muslim, we don't want this, we don't want that. So I think that we need to also connect with broader movements in terms of getting justice to tackle this hostility in terms of and human rights violation in the migration context. So, thank you.
Okay. I am an activist more than a lawyer. And for example, for that junior who was detained, the first time we lost the file. And the judge said, yes, they have the right to send him back. And the people from African descent made so much noise, so much demonstration, so much media, so much social media, that it goes back to Congo, and the president calls the Belgian ambassador to say what happened, and then he was released. Then I think it's very important to organize between ourselves to call also our embassies, because our embassies, they are paid to help us. It's their job. And when there is police violence against someone from another origin, we have to go to that embassy and to ask them. If a Belgian guy, I was to the Iraqi embassy and I said, if an Iraqi police officer killed a 2-year-old Belgian girl in Iraq, what will happen? A war. And you do nothing. And a lot of time they continue to do nothing. But but we have to call them more, that you have to help us. It's your duty.
Thank you very much. I'm looking at Louise. Do we have time for an intervention? It would be one last intervention. Yes? Okay, thank you. Sorry to insist, but...
Good evening, everyone. My name is Mohamed Hakim. I'm originally from Sierra Leone. I acknowledge the presence of the panel and the audience. Actually, it is not a question per se. I just want to share a brief knowledge about my traveling to Europe. In 2016, I left Sierra Leone, and in 2013-14, we had an Ebola outbreak. So because of that, I'm seeing my close relatives, they are dying out of that disease, you know. So I left Sierra Leone, and also Guinea. There was an outbreak, the same Ebola. So there was no way for me to stay there. I was with a friend. He said, okay, the best way we can do, let's go to Niger. Maybe there will be safer for us. So I agreed with him. And we were there, but things are not going well. He said, let's manage to go to Libya. Maybe we can work and make some money. I agreed with him also. So we was in Libya for about 4 months. But the situation there was very critical and rough. And at that time, I don't know, maybe Libya is now stable, but at that time, Libya was not stable. So someone told us about this crossing, and we have no option unless we have to, because we want to save our lives. We went to a camp, we paid our money, over 1,000 of us, and they took us to the seaside. There, we are there, and unfortunately for me, and one guy, he's from the Gambia, they forced us to drive the boat because I heard about, how do you call it? Criminalization of what? Yes. So we have been forced to drive the boat. And you have no option to say no. You cannot deny. Because you have seen someone said no, they shoot him immediately. Yeah, on the head. So who are you to say no? You have no option. You have to do as they say. And that particular moment, it was not even we that start the engine of the boat, or neither, because they gave me what they call compass. I never knew what was that. And also the guy who drove the boat, he was never a fisherman, neither a mechanical engineer. So they drove the boat for over 3 hours, and they handed over the engine to the guy. And also they gave me that compass, as they called it, in a bowl. They said I should be looking at it. After 30 minutes or 1 hour, we do not even have watch with us. So how can we tell the time? So we went for a few hours and we saw the Italian Coast Guard. They rescued us. They did well anyway. But when they rescued us after 3 or 4 hours, they started asking people, but they are calling one after the other. They took them inside one isolated place. They will be saying, we want you to point us, those who drove the boat. If you point them to us, we will give you documents. We give you a better life here in Europe. So automatically, they will be telling you fabricated stories because you have made that promise to them. So that's how we get apprehended. Upon arrival in Italy, directly they took us to the prison without no interrogation. And when I was in school, I remember they said one of the basic fundamental human rights you cannot arrest or detain someone without an interrogation. So to me, it is like they have bridged that. They have, I don't, I don't know how to put it, but they have violated one of my rights. So after maybe 5 days, we went to court. It was in court. I knew that I have committed a crime. I knew that I'm in prison. After 2 years, 5 months, 3 weeks and 2 days, I got acquitted because I was found innocent. And why I'm saying this, I want the European people to be looking at this thing. They should not just accuse anyone, because sometimes you do not know the feeling of the person. We came from a very far continent, even though it is closer to Europe, but the journey alone from Sierra Leone, you have to go to Guinea, Mali, Burkina Faso, Niger, Libya, Italy. So you don't know what the person went through. And we was in the camp in Libya, a lot of people died. Died of hunger, died of depression, oppression, you name them. So I'm pleading to the European people and also the European Parliament or government to make this system easier for us. We are not the criminals or the traffickers. They will never come to Europe because they know if they come, they will carry more penalty than any other person. So if I can say, thank you all.
Thank you very much, Hakim, for sharing your testimony and your journey, and concluding, I think, in the best possible way, this discussion today, and really calling for action, calling for us to work across movements in order to change the policies that the EU is fully participating in. So thank you very much. Thank you, everyone, and have a good evening. I know we're keeping you a bit longer than what we said on the program, but we have a final speaker with us who will be sharing a bit his reflections on this first day, and that's Mpanzu Bamenga. He's a human rights activist, founder human rights initiatives and Inc. Leaders and the Inclusion Leaders Network, and a future Dutch parliamentarian. So bear with us. I think we'll have some really insightful contributions from his experiences as well. So I'd like to invite Panzo to come. And thank you, sorry, I jumped too quickly. Thank you to all the speakers and moderator for the last panel and for the contributions. Oh, okay. Just to say maybe one word for the online participants, we apologize. There won't be interpretation as of 5:45, which I think is in a couple of minutes. We will have interpretation tomorrow, that's back. But so yes, thank you for staying with us and bearing with us for the last couple of minutes of today.
Well, thank you very much for inviting me to speak here. Actually, I should have spoken tomorrow, but it wasn't possible anymore. So that's why I'm speaking today. So thank you very much for being that flexible. And thank you. I think that the day was really inspiring to hear a lot of stories. Hakim, thank you for sharing your story as well. I think if I have to summarize what I've heard at the end, it's about looking at the other as being not a human being. So basically dehumanizing people, and by dehumanizing people, it's justified that people are being criminalized. It's justified that people are being deprived of their human rights. It's justified that people are being treated as they have been treated as many people said today. And I think that's something that we should really be aware of. The inhumane policies that our governments are basically doing also for us, because we are citizens of all these countries. And I think that, you know, we should do everything which is possible to try to change that situation, because I don't want my country to do such thing on my name. So I've witnessed this dehumanizing way of treating people myself, and I'll give you 3 examples. The first one is I'm born in Kinshasa, and when I came to Europe, I came here and I was an undocumented migrant for 16 years. And in these 16 years, I remember when I was 11, that was the first moment that I actually realized that we were undocumented, because I was reading a letter for my mother. I was translating a letter for my mother, which stated that we should leave the country and we don't have any right to be here anymore. And I remember that from that moment that I felt a fire inside of me, who basically said, this is an unjust situation, because a lot of people who look like me were in the same situation. And I said to myself that, I have to do everything which is possible to try to change that situation. And I knew that it's not a sprint, but it's going to be a marathon. It's going to take a long time to have the right knowledge, to have the right skills, to actually do something that can change that situation for ourselves and also for others. But I started somewhere, and I started to study at school. And at one point, I also started law, because that period really took us like more than 16 years. And I lived first in France, and then I lived in Belgium, and then I lived in the Netherlands. And the period in the Netherlands took us like 13 years being undocumented. And I remember it was 2006, I believe, that we received our final letter stating that we have to leave the country within 8 weeks. If we don't leave voluntarily, what someone said, then we will be deported out. So, okay, how voluntarily is that? And this is when I was just studying law for 2 years. You have to imagine in the country where I live, in the Netherlands, after being 18, you actually cannot study anymore back in the days. So you have to leave the education. But somehow I just inscribed myself at the university, and I just started studying there. And by making music, I found a way to pay my studies. So it wasn't easy. But I was studying already 2 years law, and I said to myself, you know what, maybe I should start a procedure myself. So I started writing a letter. I wrote a letter about my situation, about my vision of the Netherlands, about why I think it is unjust in our case to be returned back to the country of my birth, Congo. And miraculously, I sent the letter the last day before we were deported out. And a minister read that letter. And then I received a phone call from the employee saying that the minister read your letter and it's okay. He's going to fix it. Just like that. Yeah. So I was amazed. I said, wow, that's power, power over, someone's life, actually. And somehow, because I remember, I think it was one lady who was undocumented, who just said it like detention, right? Like a psychological detention. and this is also how it felt for me. You know, it felt like I was in a very big prison. Yes, I could move from here to there, but it was a prison where I was living in. So when that news came that we finally had a status because of that letter of mine, this is when I felt liberated, basically. But at the same time, I felt like it was really an unjust situation, because many people who maybe are not able to write such a letter, or people who are even in worse situation than I was, are being deported every day. So because I felt that unjust, I said to myself, I cannot let it go. So I have to finish my study and start to work for undocumented people. And I have been doing that for more than 15 years now, to try to help undocumented people every day, for them to have a better life, so for them to have a better future perspective. So this was one example. The other one, very personal for me, where people are being treated less than human beings, is of my sister, who had a French passport. And having that French passport, she was actually, I got my diploma. So I was celebrating with my diploma, my law degree. And she was living in the United States, and she said, you know what, I'm going to surprise my brother because I haven't seen him for quite some time. So she was coming with a French passport from the United States to the Netherlands. And when she came at the border, they looked in their passport. They said, you know, we don't believe it's you. She gained a little bit more of weight, and she said, no, it's me. And this is my French passport. So you have to let me through. They said, no, we will not. We have to examine it. And after they said they have to examine it, they started interrogations. These interrogations took some time, and then they put her in detention. And after they put her in detention, they took away her medication. And after they put away her medication, she died in detention. And that was, for me, again, when I just had my diploma, when I just was thinking that life will be much better, something horrible like this happened. Another example of how people can be dehumanized. If you have paper, or you don't have paper, you are being treated less as a human being for the simple fact that you are Black. And that was for me as well a very important moment to tell myself that more is needed. I cannot just help one individual. Of course, this is also something which is needed, because injustice anywhere is a threat to injustice everywhere. So we always have to take action if there is injustice in a place, but I have to try and do more. So that's the reason that I went into politics. First of all, in local politics, and I said to myself, what can I do? And at that moment, there were a lot of lawyers as well talking about the right of undocumented people, the fact that they had the right of shelter and aid. And I said to myself, well, no one has done this before in my country and came up with such a law for all undocumented people, to actually say all the undocumented people have the right to shelter and aid. But I said, you know what, let's just try to do it. So that's what I did. I came with a policy saying that all undocumented people in my city should have the right for shelter, and at least also the right to have aid, so that someone can help them out to have better future perspective. And it went through. And when that policy went through, I sent it to all my other colleagues in different countries, different cities of the Netherlands. And in different cities in the Netherlands, people started doing the same initiative. And before you knew, several cities did it. And then suddenly it became like a national policy. And at this moment, it is a national policy. I am coordinating it actually from Amsterdam. And the last example is after all of this, I had the opportunity, the chance to also be decorated and have a lot of prizes and being the talent, political talent of the year, and etc. etc. Still, when I came back from Italy, I came back to my city in 2018. I was stopped at the border, and there were nobody was being stopped at that moment, so everybody could just walk. But I was stopped. I thought maybe they are looking for someone who looks like me. But then I turned around, I saw that they stopped another Black person, a Black woman who didn't look like me, of course, with 2 children. And then later they also stopped another Black man who also didn't look like me. And all the white people could just walk. And then I started asking questions to the border police, like, why are you stopping me? And I see that you're also stopping other Black people. And the border police said, well, we are doing so because we are looking for criminals. And we are looking for terrorists. We are looking for people who might be illegal in our, we're trying to enter the country illegally. And I said, but how do those people look like? Because you are basically stopping only Black people. They say, yeah, we know how to stop them. We know how to do that. I say, who is giving you this competence, this power to do so in such manner? And he said, well, the law is giving us the power to do so. I said, well, the law, well, I know the constitutional law, and the constitutional law starts with Article 1, say you cannot discriminate. And this is exactly what you're doing. This is racial profiling. So because of that, I couldn't let it go. So I said to myself, I have to tackle this, because this is something that, you know, it's something that goes very deep. It says something about our government and how they look to people. So that's why I wrote like a social media post about it. And when I pressed send directly, a lot of people started to retweet it and basically started to publish it again. And then within 5 minutes, I got the media, and I told them my story. And then the media, you know, also heard the story from the border police. And the border police said, yes, of course, we stop people based on ethnicity as well. That's what we do. Is that a problem? Wow. And actually that's racial profiling, but they said, no, we don't do racial profiling. We stop people also based on ethnicity. So, okay, but that's racial profiling. Okay. So, I can say I got lucky by it because that was really like a proof to continue the case. And when I continued the case by coming up with a complaint, at first I was called by the border police saying that we want you to stop talking to the media about this. We want you to talk to us. Okay, so I went there to talk to them. And then when I talked to them, there was a second meeting. And in that second meeting, they basically said, listen, we want you to stop with this complaint. And because you're telling a lot of lies to the media. And if you don't stop with this complaint, then, we will damage your name, and we will damage your career. And they said, you know, if you just want to continue it, then we cannot stand for what can happen to you, basically. And then I said to them, okay, what shall I do? Shall I continue or shall I stop? I think everybody told me, well, you did your job. People are talking about it now, and maybe things will change and it's better for you to stop. But at the end, I said to myself, no, I cannot stop. Why? Because I don't want to live in a society where people are being judged by the color of their skin. I don't want to live in that society for myself, for my children, and also for nobody. So that's why I continued. And when I continued, they told me, we got all the facts. And the facts, all the border policemen were basically saying, yes, we stopped him because he's black. I mean, we were looking for criminals. So they were talking about it very bluntly. And they also said we were looking for a Nigerian money smuggler. Okay, how does a Nigerian money smuggler look like? Say, well, three things. He's good, you know, he's well dressed. I said, okay, thank you. I like to be well dressed. He walks fast. Yes, I was walking a bit fast. I was going towards my work, and it was raining a bit. So yeah. And he has a non-Dutch or non-European look. So non-Dutch, non-European look. What is a non-Dutch, non-European look? Well, okay, that was the question. We came to the hearing, and then the chair of the hearing said, well, Mr. Bamenga, you hear, this is their job. This is what they have to do by law. They have to make a division between Dutch people and non-Dutch people. And that's why they stopped you. I said, wow, but can you explain to me how a Dutch person or a European person looks like? And then the chairman said, well, you can imagine that you don't look like a Dutch person. Okay. So that was the reason, even though I won that case, that complaint, but still the law did not change, the policy did not change. So that's why I gather together with Amnesty International, together with Control Alt Elite, together with Radar and PILP, and also Hout of Advocaten, and also a pilot named Robbie. We gather our strength and we said, let's start a court case. We started the court case. At first instance, we lost the court case. And that was actually an example of institutionalized racism, because even the court said in their ruling that, yes, a skin color can say something about where a person comes from. Not necessarily, but it can say something about where a person comes from. And that's why they can do it. And we were all in shock that even the court, you know, justified this behavior. And there is a very beautiful article at Al Jazeera saying a court just confirmed to be Dutch is to be white. Yeah, that was very painful. And from that moment, a lot of media attention, even more media attention came. And after that, we went to second, you know, we appealed. And in the appeal, finally, the judge said that, you know, that this, you know, this way, that the border police is basically racial profiling, and racial profiling is a very, you know, it's racial discrimination, and they should stop immediately. So, and that's how we managed to stop the policy, to change the policy. And even though when we changed the policy, our government reacted to it. And instead of saying, okay, now things will change, no, they said, you know what? This only has consequences for a very small part of the border agency. That was also very disappointed. So I'm closing. So right now in the Netherlands, we have the extreme right, who just won, right? And it's the first time. And the reason, if you ask me, is because they have been normalized. Yeah, nobody was trying to vote for them because they say, oh, if I vote for them, I'll be a racist. I don't want to be a racist. But now they are normalized. Yeah, racism is more and more normalized. So it's fine to vote for them. But there is also hope. And that's what I would like to end with. There is hope of decolonization. There is hope of people who are trying to dismantle racial discrimination. And that's what I heard today. There is hope of people who's trying to bring racial injustice into the light. Hope of lawyers. academia, NGOs, of PICUM, of many people, Equinox, who's trying to bring the human dignity back of the people. And also hope of undocumented migrants themselves, like the stories we've heard today. And also the story I've told you of an 11-year-old boy who actually dared to dream when he was 11 and said to himself, you know what, we have to change. We have to change the policy, even though it won't be changed tomorrow, even though it's not a sprint, but it's a marathon. Dare to dream and dare to do. So that's why let us go forward to continue to combine our strengths together and come up with strategies and direct action that will change the world and that will make sure that we all respect the human dignity. And I believe next week I will be sworn in as a parliament member. I think my first action will actually be to make sure that racial profiling is within the law and that it will be forbidden, not only for the border agency, but for all agencies and for all part of the government. And I believe that if we combine our strengths and the strategies, we really can make sure that this ends and we can do it together. Thank you.
Thank you so much. Don't worry, everybody, I won't make a speech. It's just to say thank you very much, Panzu, and thank you very much to everybody here today who reminded us that the issues that we're talking about here are real life. It's not a game and it's not a job that ends at the end of the day. It's serious and it's urgent and we have a lot of work to do. So thank you for that. Thanks for everyone for coming. It's been really great to have you here today, especially the interventions from the audience and the many speakers that we've heard today. You're welcome to stay with us for a drink after and a little bit of food. So please do that if you have the time. Tomorrow we'll start again at 9:15. Registration will be from 8:45 onwards. So we're looking forward to see you bright and early. And one more thing, we'll have some workshops tomorrow. One on grassroots organizing and what can be a way forward at the national level and at the grassroots. One on anti-racist advocacy, and one on movement lawyering and community-based approaches. These are really some really important discussions that we think we need to happen. We've heard a lot of pain and we've had a lot of trauma here today. And I think we really need to focus on what we're going to do meaningfully forward. And how can our approaches forward be informed by a racial justice approach? So please sign up for the workshops outside, and we're looking forward to see you tomorrow. Thank you.